gavel in front of me tonight, so I hope everyone behaves, okay? But- All right, folks, we're good to go. Welcome to the meeting of the Harwich Board of Appeals on this date, April 30th. The purpose of this meeting is to hear and decide applications before the Board of Appeals which have been brought pursuant to the bylaw of the town of Harwich and the Massachusetts Zoning Enabling Act. As required by law, the town may audio or video record this meeting. Any person attending to either audio or video record this open session is required to inform the chair. During the meeting, the chair will recognize promptly a member of the board, the secretary, attorneys presenting the case, to inform the chair if a protocol is not being followed. While in open session, those wishing to present comments or ask questions regarding the case are requested to fill out an information form on the podium, which is just you need to fill it out for us who you are and so forth. Now, I'd like to begin by asking all the board members to identify themselves.
Tim Bailey.
Kenneth Dixon.
Brian Sullivan
Alexander Donahue.
John August.
Marilyn Roths.
and Rachel.
Rachel Lohr, Zoning Compliance Officer.
Okay, thank you. And why don't we start here by having you call our first case? Here you go, Al.
All right, case number 2025-14, Elizabeth Mobashley. Sorry if I mispronounced that.
Good evening.
The owner of the property is located at 19 Shannon Road, Assessors Map 41, Parcel T29, in the RR zoning district. The applicant seeks a special permit from 325-54A2, non-conforming structures and uses, and 325 Attachment 2, Table 2, area regulation, and 325 Attachment 3, Table 3, height and bulk regulations to enclose a breezeway and raise and replace it, attached garage on the pre-existing non-conforming single-family dwelling pursuant to the Harwich zoning bylaws 325-54 and Mass General Law 40A, Section 6. This case has been continued from March 26.
Okay. Good to see you again.
Hey.
So when we continue this case, we're in open session, and the purpose of the continuance was give the opportunity to the applicant to update the site plan to show the correct building site coverage.
Yeah, the required modifications were.
Okay, which I think we've all received. Everyone take a look at that?
Yep.
Okay. Do you have any further comments on that, so forth? Okay. That being the case, Joe, the board, I think we can proceed. And I don't recall, probably did not, but you have a, I don't know if you still have it, a copy. I don't believe it went into the findings and so forth at the last meeting. Okay, so, since, you have an extra copy of the findings for, on 19 Shannon? You have a copy as well, right?
I do not, I was not at the meeting.
Okay, you have a copy of the 19 Shannon?
No, I don't.
Okay, all right, so. Okay, no, okay. That being the case, I'm just gonna quickly just go through, we're now going to review, and again, folks, if you're listening to this, we went through the whole presentation last time, and the only thing that needed to be changed was approval for the, regarding the building coverage, which is fine. So we had received the first documents on this, the application, certified plot plan, which has now been updated. And we had a letter from the building official who initially denied the application, and also interdepartmental comments and site summary dated on March 14, 2025. Okay. now that new plan has been updated. What's the date of the plan, Rachel? Do you have it right there?
March 26, 2025.
Okay. So the plan summary date is March 26, 25. The findings that we reviewed at the last meeting as well is that this is a lot, it's in the RI zoning district. Property is located, the lot is pre-existing non-conforming regarding area requirements. The existing dwelling and attached garage are pre-existing non-conforming regarding easterly setback. Existing dwelling is conforming regarding the north setbacks. Site coverage will increase. Site coverage increased to 18.7, where 25 is the maximum. Building coverage, which is currently 12.6, will be increased to 15%, and which is conforming. The project proposes to raise and replace an existing attached garage and breezeway within the required setback, requiring a special permit. The structure remains single-family dwelling. The addition and renovations will not create any additional negative impacts with respect to traffic, noise, odor, and congestion. And a violation of terms of these conditions, the special permit may be enforced as a violation of the Howard zoning bylaw pursuant to GL 40A, Section 7. The discussion last time, we reviewed for motions, which would include, we don't, I think in our discussion last meeting, we decided the fact that we did not have to review, have the date requirement. Is that correct? Okay. So there's gonna be no date requirement for construction. The applicant, during the construction, will need to keep his vehicles parked on the property, and the violation of terms and conditions, the special permit will be enforced as a violation of Howard zoning bylaws pursuant to GL 40A, Section 7, and the Howard zoning bylaws, as this may be amended time from time.
Brian, what,
Are there any questions regarding, from the applicant or the board regarding these findings?
the number you quoted for the site coverage, what was that? I think you said 18.7?
18.2.
It's 18.2 on the new drawing, right? But what is it on the statement of facts?
I get pulled the drawing out to take a look at
Where's the
it.
drawing? I
Now,
got
you were
that.
reading off the statement of facts, I think.
Yes,
What's the statement of facts, Brian? He's asking what the statement of facts said.
Yeah. The drawing says 18.2.
7, that's right. Second?
We can amend that to 18.2.
$18.2, that's
Yep.
correct. Okay, thank you.
The new drawing, 18.2.
Okay. I'd like to make a motion that we accept the findings of facts, the documents, and the conditions for approval.
So moved.
Okay?
Second?
All those in favor?
Aye.
Okay. And I'd like to have a motion to close the public hearing.
So moved.
I have a second, please.
Second.
Second by Tim. All those in favor?
Aye.
And, Bailey, John August. So, present at the last meeting and tonight are just four of the board members, which is Al Donahue, myself, Timothy Bailey, and John August. And I do believe we're gonna have a positive vote here, but you do have the right to say you wanna continue, because we don't have 5 voting people. But I would suggest the fact that you say that everything's fine, you don't wanna have a continuance,
Yeah,
okay? So assigned for voting tonight, again, as I just stated, are Tim Bailey, John August, Al Donahue, and myself. And I'd like to have the clerk, first of all, I'd like to entertain a motion to close discussion.
So moved.
Can I have a second, please?
Second.
All those in favor of closing discussion?
Aye.
Aye.
Approved. And we don't believe we need any further discussion by the board? Al, you can make the motion, I appreciate it.
Okay, case number 2025-14, Elizabeth Mabasu, owner of the property located at 19 Shannon Street. And the board has
Granted, a special permit.
applicant has been granted a special permit, 325-54A2, non-conforming structures, uses, and 325, attachment 2, table 2, area regulation of 325, attachment 3, table 3, height and bulk regulation, and 325, attachment 3, table 3, height and bulk regulation to enclose a breezeway, raise and replace attached garage, and pre-existing non-conforming single-family dwelling pursuant to the Harwich zoning bylaws, 325-54, Mass General Law. Chapter 48, Section 6. Granting is consistent with the Gale and Diedrich and related cases, as will be an intensification of one or more existing nonconformities, no new nonconformities, and no substantial detriment to the entire neighborhood on a pre-existing nonconforming lot. As proposed, the structure will not create any additional negative impacts with respect to traffic, noise, odors, or congestion. Any relief not expressly granted hereunder is hereby denied, and all work shall be performed in accordance with the plan submitted with the application.
Skip that over here.
Oh, okay. Let's see. During the life of the project, or at the approval of the life of this project, all construction vehicles will be parked on the applicant's property, not any public streets or roads. Any violation of the terms and conditions of special permit may be enforced by as a violation of the Harwich zoning bylaws pursuant to General Law, Chapter 48, Section 7, and the Harwich zoning bylaw as these may be amended from time to time.
Can I have a second for the motion?
Second.
All those in favor?
Aye.
Aye.
Motion is approved, 4-0. Thank you. You have your,
Appreciate it.
so in about another week, it will be filed with the town clerk. At that particular point, you'll be able to then, within 30 days, begin the project, or at least apply for the
Go
building
for the
permit,
permit.
okay?
Appreciate it. Have a good meeting.
Al, can you read the next case?
It's the other one.
There you go. You want to give it to you, sorry. There you go.
Case number 2025, excuse me, -15, Jeffrey Lang, manager of 11 River Bend LLC, through his attorney, Andrew Singer. The owner of the property is located at 11 River Bend, Assessors Map 1, parcel G1-9, in the RL zoning district. The applicant seeks special permit for 325-54A for a 4 and 5 non-conforming structures use, and 325, attachment 2, table 2, area regulations to freeze and replace, excuse me, pre-existing non-conforming single-family dwelling detached garage pursuant to the Howard zoning bylaws of 32554 and Mass General Law, Chapter 48, Section 6. Let me see, I'll just go through this. There's no comment from the town departments
Oh, yeah, Harwich,
of Howard.
Harwich Conservation Department.
I'm sorry. Okay, Howard Conservation Department submitted comments that the project will be the Conservation Commission on April 16, and that they would be recommending they approve the project. The planning department had no concern. Other comments from other town departments and butters will receive. The chairman, let me see.
We have, since prior to this draft, he did receive comments from the butters. Okay, which I'm sure the butters will be speaking tonight, I'm sure. Chair, I'd like to ask the applicant to introduce themselves and who is assisting you.
Thank you. Good evening. For the record, my name is Andrew Singer, an attorney in Dennisport, here on behalf of the applicant. With me at the table is Dan Croto from Moran Engineering, the project engineer. In the audience is Antonia Butwell, who's a project architect, and also Jeffrey Lang, one of the owners of the property. We appreciate your time this evening to discuss this property. If I might, Mr. Chairman, I have, to help orient the board, in light of the abutter comments that came in this afternoon, I have an additional handout if I could give to you. This is, let me say it while I'm in front of the microphone. The first part of this is one of the land court plans showing the road layout, and then below it is two photographs. There's an X on the plan. The photographs I took, they're just showing the road, one looking south, one looking east. And then it got a little confusing, and so Dan prepared a new, just an updated colored sketch showing the square footages. So what's on this, the red is the existing house, the green's the proposed. We just think it's going to be helpful to the board in looking at it. And then finally, I only have one copy of this, Mr. Chairman, but maybe you could, this could be handed out, just a pass on.
Sure.
This is a copy of the 2010 Google Earth image showing the house. And this is all be relevant as I'm talking. This property is, as I just handed out, a very unique property. It is on River Bend. It's actually wrapped by the road layout on three sides and by the river, Herring River, on the other side. So they have very odd shape and certainly significant environmental considerations that are going on with this property. Right now, there are two structures on the property. There is a single-family dwelling that is, actually, the decks are over the water, so it's beyond the rear property line, encroaching into the river itself. And there are setback nonconformities to the dwelling, and there are also setback nonconformities to the detached, nonconforming accessory residential garage structure. And as I pointed out on this, I handed out, if you, the first page, the little X is where I took pictures, and you can just see how the road wraps around the property, on the east and on the south. The dwelling itself is partially located in the velocity zone as well as the AE flood zone, and it is the garage is in the AE flood zone. So the garages and part of the house are outside the V zone, but a good part of the house is in it. All of the property is located within the buffer zone to the river. I mean, there's just nothing on this property that's not wetlands jurisdiction. As I noted, the existing dwelling and the garage are each set within the respective front setbacks of the wraparound road. They're also well below base flood elevation. In fact, the basement of the house regularly floods. So one of the ideas here, and that's working with conservation in particular as well, is to solve these environmental problems on a tough lot. The applicant is proposing to demolish both of the structures, which are shown in red on that handout that I gave you, and they're proposing to replace them with a less nonconforming, flood-compliant, elevated, single-family dwelling on piles with a deck, and that's the green that you see, and we'll discuss that in more detail. As referred to you by the zoning enforcement officer, we've applied for a special permit in accordance with section 32554 of the local zoning bylaw and MGL 40A section 6 to complete the work as shown on the plans. The zoning bylaw provides that pre-existing non-conforming single-family residential structures may be demolished and replaced with a new structure on the same site by special permit upon a finding by you that the proposal meets specified criteria, most importantly, that the proposal will not be substantially more detrimental than existing conditions. You have, the chairman mentioned that you received a lengthy letter from an attorney for the abutters this afternoon, and I see that he's on Zoom, and I was copied on that email, so I thank you for that. I have had a chance to look at that, and I did want to discuss that. In his letter, he raises allegations about your jurisdiction and the application itself. And I will discuss why it is my opinion that these respectfully are in error and that the application is properly before the board, including reference to relevant case law that was not mentioned and stated case law that's inapplicable in this instance. First, however, I would like to discuss why the applicant respectfully submits that the proposal meets all of the criteria of the desired and requested relief and will not be substantially more detrimental to the neighborhood than existing conditions. That's the underlying threshold that you have to look at no matter what we're doing. Excuse me. In this instance, single-family residential use is permitted in the RL zoning district, and that's not changing. The pre-existing non-conforming westerly front setback of the wraparound road will remain the same, and its corresponding on the north side as it wraps around is going to be slightly less nonconforming, going from 9.1 to 9.0. On that westerly side, on that easterly side, and on the sheet that I gave you, that would be the long segment of the road layout there. We believe that the Lang family actually own the fee in that part of the way. However, it's not included as part of the setback. So the setbacks are measured from that interior line on that lot. This proposal is actually going to result in a smaller house. It's going to be elevated, but it's going to be a smaller house. At the moment, the house is pre-existing non-conforming because not only is it greater than 30 feet in height as calculated by the zoning bylaw through the average natural grade, and Dan prepared a handout that you should have noting that. It's 31.5 feet, I believe. But in addition, it has a third level of human habitation. And the bylaw, although the table 2 says that houses can be 2.5 stories, there's another section of the bylaw that notes that you can only have 2 stories of human habitation other than a family room and a basement. And this house, and I showed you that Google Earth image, I believe the house predates the current ownership. We have Google Earth images from 2005 and 2010 showing that the structure's there. Well more than 10 years old, so it is a pre-existing non-conforming structure under 40A, I think it's 17. That's going to be eliminated. So the proposal is going to actually propose a 2-story house on piles, but we're getting rid of that third level of human habitation, and the full basement's being removed as well, because the house will have to be on piles, as you can see on the plan. So as a result of all of this, building coverage on the lot is going to go down. It's going to be conforming, but you can have 15%, is 9.8% now, and it's going to 8.3. So the elevated house footprint is going to be smaller than the existing dwelling, and that's not even counting the garage. You factor in the garage square footage, there's even more of a decrease of square footage on the lot. Further, it's not only the footprint that's going to be smaller, the gross square footage of the dwelling itself on both floors is going to be smaller than the existing space, and that's not even counting the basement that's there now. Dan did not include that in his calculations. So the decrease in gross floor area of the house, and that's all listed on this sheet that I gave you, the numbers are all called out, that's actually going down for the house-to-house, and even more when you get rid of the garage, because there will be no replacement. You know, the garage is going to be eliminated. That will not be there. Building height, as I noted, is pre-existing non-conforming. It will be rising 2.3 feet to 33.8 feet. However, that's in part because of the piles. You know, the house is being elevated to move it up and out of the velocity zone, which is something very important to the Conservation Commission. And interestingly, and you'll see this on Dan's chart that he gave you, he has a middle calculation showing that the Harwich zoning bylaw allows owners to elevate existing houses, like for like, not replacing a house, not changing. If your house is here in the floodplain, and you want to get it out of the floodplain and just jack it up, you can do that up to the base flood elevation by right under the zoning bylaw. If the owners had chosen to do that, it would leave the house on the river and within the velocity zone area, but they could actually put by right a taller house, or I'm sorry, the house would be taller than what they're proposing. If you took the existing house and jack it up to base flood elevation, the house is going to be the height it is today, but now higher. They're proposing a house that is going to be almost more than 5 feet below what that would be. So it's higher than what's there today, but only by 2.3 feet, and it's going to be lower than what a less environmentally friendly house could be done by right. So, and we can discuss that, but I wanted to put that on the record that we believe that although there will be a nonconformity and it'll be intensifying, that's why we need a special permit in part, that it is not going to be substantially more detrimental for those reasons that I initially just relayed. In addition to building coverage going down and the building size going down and the gross square floor area going down, zoning site coverage is going to be reduced as well. 30% is allowed, there's 19% today, and it's going to be 17.5% proposed. So everything on this site coverage-wise is getting better. The wetlands site coverage within the 0 to 50-foot buffer to the river will be reduced from 4,075 square feet down to 3,640 square feet. And you had that comment from the Conservation Commission. Dan was at that meeting a week or two ago. It was continued to another meeting to answer some final questions, but it was positively received by the commission as, you know, the green that's on this plan that you have as being significantly environmentally better than what's there today. And that's their jurisdiction, obviously. The Board of Health will also be looking at this. There's a septic system now, and it'll have to be upgraded, but it'll remain. We submit that there'll be no negative impact on water supply, drainage, or septic service, and to the contrary, that there will be improvements with the new flood-compliant dwelling. The proposal will be in keeping with and compatible with the character of the neighborhood and will not adversely affect the neighborhood. The proposal will not cause or contribute to any undue nuisance, hazard, or congestion. And the proposal will not adversely affect the public health, safety, convenience, or general welfare of the town. I would like to, and I alluded to this before, I would like to address in part the letter that Attorney Hill submitted. I believe that there are 3 reasons why his analysis is inapplicable or in error in this case. The first is that the zoning enforcement officer for Harwich did not agree and referred the matter for a special permit, and that's what we applied for. Second, the court cases cited are inapplicable. They included Rockwood, for example, which I know many of you know, but Rockwood deals with commercial structures expressly, and courts have said that it does not deal with other than commercial structures. In addition, there's no reference to the Gale or the Dedrick cases, which I know you're very familiar with. You see them all the time. And both Gale and Dedrick and Batala, following on that, say that residential structures are pre-existing non-conforming the non-conformities can be extended, they can be increased by special permit. Now, if they're not extended or intensified, the court cases say that the zoning enforcement officer approves it by right. Don't even need to come to you. But when there is intensification, and we have that, an applicant has to come to you for a special permit. What the cases all say as well is that if you create a new nonconformity, you need a variance. In this case, we respectfully disagree with Attorney Hill and believe that we're not creating any new nonconformities. We are lessening and eliminating nonconformities certainly not in part intensifying, but in no way is this creating new. And third, and this is very important for your analysis, all zoning cases are fact and zoning bylaw specific. And if you read all of those cases, and you've read many of them, they all turn on just nuances of what's exactly proposed. Sometimes they're houses, sometimes they're garages, what the bylaw says. And every zoning bylaw is different. And I'll refer briefly at the end to why I believe the Harwich zoning bylaw provides express coverage for what the applicant is seeking. As far as cases, there is one other that Attorney Hill mentioned that I would like to note because the proposition is inaccurate. It's the 2024 court case, it's a land court case of Cronin versus Fitton. And Attorney Hill raised it for the proposition that detached garages are not eligible for review under 48 Section 6. And for two reasons, I respectfully disagree with this. First, land court cases are trial court cases. They have no precedential value. Only appeals court and SJC cases are ones that can be relied on in Massachusetts. Secondly, that land court case is the second time it's been to the land court. The neighbors have been fighting each other in that case for a long, long time. And so even that is still in the trial level. Second reason, the judge did say, and the quote is accurate, the judge said that in his opinion, a garage is not covered by 48 Section 6. But then in the very next breath, he acknowledges that it might be ruled otherwise upon further court review. Specifically, he wrote in his decision that if the plaintiff wanted to, quote, pursue and prevail on remand, end quote, on the garage being included in 48-6, then they would have to satisfy the Balata tests and obtain ZBA findings regarding nonconformities and intensification. And that's exactly what we're here before you this evening doing. And we're here before you doing that because of those special provisions I mentioned of the Harwich zoning bylaw. There are three types of accessory buildings in Harwich under the zoning bylaw. 325 Section 2 defines an accessory building. It separately defines a residential accessory building. And then in 325-14Q, it provides that accessory residential buildings that have bedrooms are treated differently. If they need a special permit, if they have bedrooms, and they don't need a special permit if they don't. 325 Section 18G. So 325-18G notes that all accessory buildings in town of Harwich, no matter which of the three types it is, must meet the principal structure or use setbacks for the property, unless you're under 100 square feet and 12 feet in height, then you can be within the side and rear setback. But in this case, the structure that's here is greater than that. And so the structure that's here, the garage structure, is a residential accessory building as defined in the Harwich zoning bylaw. And it is covered, therefore, because it's treated separately, in my opinion, under 325-54, and as well under 48 Section 6. I think that is a very straight line interpretation that can be made, and I believe that when you look at the cases that were both mentioned and not mentioned, that is covered. And for all the reasons that I mentioned, and I'll stop now because I know I've been talking for a little while, and Ms. Rouse, who's might be her first meeting, is probably wondering why I had to be the first big meeting she was sitting on. But for all the reasons we submitted and wrote, we believe respectfully that the proposal is before you properly, that it is not substantially more detrimental, that the intensification of the height is reasonable in this instance. It's not going to, as it's relocated, block views, not that views are protected, but it's not going to. And in addition, we're reducing one of the setback encroachments, which is required under 325-54A5. If you have questions for any of us, we'd be happy to answer them. We appreciate your review, and thank you very much.
Thank you, Tim. Appreciate it. Can I ask the board if you have any questions?
No questions for right now.
I just would only want to confirm that one of the issues obviously raised by another attorney was building height. I don't see that that requires any type of a special permit. Can you explain to me if height is an issue in this case?
I believe, I believe, I won't say an issue in the sense that there's a problem with it, but I believe it is appropriately before you because and this is that sheet which Dan prepared, I think you should have it, which clarifies that measuring the height based on the zoning bylaw definition of average natural grade around the house, right now we're over 30 feet. So we're pre-existing non-conforming. If the new house, even elevated on pilings, was going to be able to be 30 feet, then I would tell you that we're eliminating that non-conformity, and then it wouldn't be a subject of concern. But in this case, because it's going up 2.3 feet, it is extending it vertically, and so I believe it's appropriately before you as a special permit, as part of the special permit, that it is not substantial, and the test is not substantially more detrimental.
So I'm looking at the application, it says 26 feet.
That was an error.
Can I interrupt for a
Please.
second? Folks, a lot of it, in this case, the board received a lot of information in the final hours today. So we have board members that may not have noticed additional updates. So originally, in this case, the application showed that the height was conforming. It was going to remain conforming.
Okay.
Upon further investigation by Rachel and myself, and looking at it, we realized that we felt that the calculations for building height was not done properly.
Okay.
And Rachel got a hold of the engineers, reviewed that with them, and then they came back with their updates, which indicated that the existing house is already non-conforming building height of 31.5. However, that current building on construction and so forth, it's over 10 years old. So because of that, the existing building height of 31.5, which is non-conforming, is actually, now it's a pre-existing non-conforming, it's allowed.
Correct.
Okay. Now, the new calculation for the proposed new construction, the building height is gonna be 33.8.
Correct.
So that
That helps, thank you.
helps.
And we apologize, the original, we did the height based on, from the base flood elevation.
Correct.
Which, and so that was an error on our part, and so we updated it, and we appreciate that.
But fortunately, the board and Rachel, we picked up on that. So-
Yeah, we appreciate that, thank you.
Dan Caroto from Moran Engineering. I think the building height calculation was changed in 2019 for FEMA to make existing buildings be able to be raised in floodplains without going to zoning board of appeals. At that time, it became confusing. Under building height, it sends you to the floodplain part, and in floodplain, it doesn't give you a different way to calculate building height. So after speaking with Rachel, I completely agree with her take that the building height should be calculated at the building definition, even though the floodplain zoning bylaw gives you the right to go right through that building height in order to meet.
If it was the same house, if you were just jacking up the same house.
Correct, but the original, getting back to it, the original was just based on the base flood elevation, which would have been correct in 2019, but is no longer the method to do it.
Thank you.
Thank you.
No other questions?
And there'll be no demerits issued by the board.
I just want to clear it.
I just want you to know that. The other thing, which I learned today, I believe the floodplain elevation here is 13 feet by the floodplain, but the town requires you to be an additional foot over that. Is that correct?
Building code.
Building code.
State building code,
Right.
which is going to change in July.
Which brings it now to, the floodplain is 13, it brings it up to 14, what you need to accomplish for the building code.
Correct. FEMA's is the 13, and then state building code is 14.
Right, okay, so, okay. In looking over the plans and reading and listening to your review and reading, and I know Attorney Hill is speaking during public time, but there's been discussion regarding the garage and its setbacks, et cetera. And you even referred to it regarding the garage situation as far as on a detached garage. But the new plan, you have no garage.
Correct, it's being removed.
Right, so I personally got a little confused regarding the issues on the garage when, and I've been going back over the plans, to realize there is no garage being built on the new construction. Okay, so I just want to make sure that I'm not reading anything wrong here. Okay.
No, you're reading it correct, and what we are suggesting, and what's being questioned by Attorney Hill, is that if you look at the green where it overlaps the red, you can see that to pull the house out of the V-zone, it's being kitty-cornered and, jacked out of the V-zone. But by doing that, at two corners, and you can see the green there, it will be, a little bit further back, 9.1 feet back from that, because the lot's so small, that's how you can get there. My belief is that because both of the structures are pre-existing non-conforming, and because I believe they're both residential non-conforming structures,
see what the issue is.
that's why I believe you can reuse that.
Okay, now I understand the issue, all right. Wasn't quite sure.
Yeah.
Okay.
Al, I have no questions.
You mentioned, I think, Attorney Singer, that the existing owners were not the ones that built the structure that's non-conforming. Is that correct?
I said that, and I'm gonna actually turn around just for a second.
No.
The house
we've
was
not
there.
built anything that.
So you purchased it in the state it's in right now?
So, for the record, Mr. Lang said that they purchased it as it is today.
Really?
Yes, my question is, I would like to understand more clearly why the house is cocked at the angle that it is, why the new house is not going to be placed approximately where the old house was, that then would solve the problem of the north setback.
If you look at this plan, Ms. Rotz, you see the dotted black line that goes through the red house now?
Yes?
That's the velocity zone. And so the velocity zone, the house is mirroring the velocity zone. So the house, because that's how you can get it out of the velocity zone.
Thank you.
And the velocity zone is the coastal high hazard flood area that, as a designer, you want to get out of. It's the most dangerous flood zone there is, and there is room on this lot to get out of that. We can't get away from the other resource areas, but we can get out of the velocity zone. It's set up so the deck that will, because the lot's so small, the deck will still extend into the velocity zone. That is going to be self-supported, so that will not be part of the house structure. And that's required in FEMA and building code regulations, that the two structures are not connected in this situation.
I think that partly answers my question. Thank you about the velocity zone, but I'm still not clear why the house needs to be hanging out on the north side so far. Why couldn't it be turned to mirror not exactly location, but orientation of the existing house, and still stay outside of the velocity zone?
The one thing that we're not showing, well, we'll show on the main site plan and not on this, is the septic system. And that septic system is up in that northeast corner. So we can't straighten it out in line with the existing house at the location because it would get on top of the septic system. In 20 years, maybe, there would be no septic, and what you're saying would be possible, except for doing an extremely small house, it would be challenging to mirror that angle. And I don't know if, even if we did mirror the same line, I don't know if it alleviates too much and I guess the neighbors' concerns. It seems though this location, it's getting out of the way of most of the neighbors, and it seems like it's getting out of the way of the high hazard zone. And it's not as high. If the house was rebuilt in the same location, it's much higher.
And in this particular instance, on this particular lot, it's about as far away, it's not very far, but it's about as far away from the water as you can get, even though it's not very far.
Yeah. That could be changed, so,
All right, thank you.
thank you.
Thank you.
Okay, I'd like to ask for any questions or comments from the public. And I believe, oh, yes, why don't you, yes, go right ahead. And your name, please.
Noreen Kalen, West Harwich. I have a lot of concerns about what's going on with this property. First of all, they're in the 50-foot no disturb zone. They should not be able to move off the footprint at all. According to the town bylaws, the Harwich Wetlands Protection Regulations, they must stay in the footprint. There's no new buildings. The only way they can move from the existing footprint if it protects the resource area. They're not protecting any resource area. They are getting closer to some of the resource areas, the salt marsh. This property is right on the river. The reason it got continued from the conservation meeting is because of this issue. The fact that it's supposed to be on the same footprint, and they have no plans showing it on the same footprint. So that's why it was continued. And I do not know why the Conservation Commission said they would recommend the change, because it's in this 50-foot no disturb zone, and, you know, there should be no allowance to be off the footprint. Now, this location is where they're trying to put in a scallop farm. And it's a commercial scallop farm. So there's a lot of concern that they're saying it's a single-family residence, and it's gonna be a residential structure or dwelling. We think they plan on using it for the commercial scallop farm. Currently, they do not live at this house. They do not plan on living there. They rent it. It's been rented on Chatham Properties, and it's still listed there. It's rented as a unique house right on the river. They do not live there. They live on another house on the Heron River further down, and they are staying there. That is, you know, the lawyer mentioned a case relating to commercial. I'm sure it's because they are putting a commercial scallop farm in there. You know, so what's the structure for? What are they planning on doing with this structure? It appears to have two front doors. Why are there two front doors? You know, they should not be able to go off the footprint. There's no new structures allowed in the no disturb shown unless it's, you know, helping the resource area, but it's not. The neighbors are concerned because of this proposed commercial scallop farm and whatever else they're gonna do there. It is not something that should be approved. You know, it is not gonna help the neighborhood. You know, they mentioned that they don't block everyone. I was speaking to one of the neighbors. She's gonna be blocked by this, you know.
What do you mean by blocked? I'm sorry.
Oh, I don't know. One of his comments, he just kind of said the new house would not be detrimental to anyone's, you know, the houses in the neighborhood. I realize, you know, when you're the front house, if you go higher or you build, you know, anyone behind you, obviously, you know, you're the front house, you can't do anything about it. But I got sidetracked on that.
Sure, I'm sorry, it was my fault.
You know, on the height, the town only allows 30 feet, so that, I guess that's why we were talking about the height, and it's above the allowed height. You know, I guess my biggest issue is that they really should not be able to build off the footprint. They need to stick to the existing footprint. And we're concerned because it's a commercial scallop farm that they're putting in there, and we believe that that's what they're gonna use this structure for. They don't plan on living there. I don't think anyone else plans on living there. You know, so what is this new structure for? So, thank you.
My fault, thank you. Just to brief comment on Noreen's thoughts, and I think they're well said, but clearly the issues on the Skull Farm, any intrusion in the wetlands and so forth, that all comes under the Conservation Commission. And if we do go forward and do a relief tonight on a special permit, anything like that would be conditioned that any building permit is required, approval from the Conservation Commission. So they have jurisdiction over that. We don't on this board, right?
No.
Right.
Okay,
Now,
you're
I
saying it would be conditional? Sorry.
Anything approval we do tonight, if we do approval, it's conditioned, any building permit is subject to the approval of the Conservation Commission. Okay. And I know we have online here Daniel Hill, and I was wondering if we can unmute Attorney Hill, please? Okay. I think Attorney Hill, I believe you're, should be unmuted.
Great, thank you very much, Mr. Chairman. My name is Dan Hill. I'm an attorney, a land use attorney based out of Boston, but I am from the Cape. I'm actually born and raised in Dennis, and spent many years down in Dennis and Harwich and Brewster area. But I'm here tonight representing the neighbors and the abutters to this proposed project. I did submit this afternoon a 7-page letter outlining the legal arguments for why we feel that this project is not properly before you, and for why this board just simply doesn't have the legal authority to issue the special permit that Mr. Lang is applying for. I appreciate the arguments that were made by Attorney Singer. I listened very carefully. I've been taking some notes. I can certainly respond to those. But in the interest of time, I just think it would make sense for me to summarize my main points. And I do want to thank the board up front for giving us this opportunity to make these comments, and for holding this hybrid meeting to accommodate everyone's schedules. So just to start with, Mr. Chairman, if I may, there are 3 reasons for why this application just simply is not tenable and cannot obtain the relief that it's asking for. First, that the project is going to increase setback nonconformities on the north side of the property, which is contrary to your bylaw, section 54A5C. The project will not decrease an eligible nonconformity. That's contrary to section 54A5D. And the project will either increase or create a new building height nonconformity, which would require a zoning variance under the applicable case law, which I'll get into. I think we all can agree that the law governing grandfathered structures in Massachusetts is very, very difficult for anybody to understand. It's difficult for lawyers to understand. There are cases, actually from the Cape, as we all know, from Rockwood and Dedrick and Gale. There's a lot of case law that even judges struggle to interpret and understand. But there's some major points, some main points that I think are pretty clear. And I think what we can all agree on is to qualify for a special permit under Section 6 of the Zoning Act, which then applies to your bylaw, the extensions or changes to a non-conforming structure must comply with the zoning ordinance or the bylaw. In other words, you can't extend or modify a grandfathered structure and then have those extensions not comply with the bylaw. You cannot create new nonconformities. And then the special permit granting authority here, the zoning board, must make a finding that the changes are not substantially more detrimental. So you're all familiar with those standards. I'm not going to get into those. You know them well enough. I am not going to address tonight that the standard of substantially more detrimental. I'm only here tonight to talk about the very narrow legal issues. But certainly, if I'm wrong on my legal issue arguments, we still think that this project is substantially more detrimental, given a lot of the different factors that people are going to raise tonight, my clients, the neighbors, and others, how this project will be closer to the northerly property boundary, closer to the abutters on the north side of the property, and have a taller structure within the front yard setback on that north side of the property. Under the zoning laws, I think we all understand and agree that single family residential structures are especially protected. There's a certain special protection under the second except clause. And one of the problems associated with this application is that the applicant is assuming that this garage, which is in the northerly setback, the 25-foot setback, that this garage qualifies as a residential structure. And I submit that it does not. And Attorney Singer's correct. The cases I cited were land court cases. There's 2 of them. There's also an appeals court case that isn't directly on point, but it's the case that the land court judges cited. So while it's true that these cases are not binding on the zoning board, they're all we got. And they're the only cases that speak to whether garages qualify or don't qualify. So I'll submit that if there's litigation in this case, we're all going to be making the arguments that the land court judge in these cases relied on and made in those decisions. What's interesting here is that the existing house complies with the setback on the north side, right? It's more than 25 feet away from that northerly side setback. But what they're proposing to do is move that house into that side yard, into that front yard setback. And just to clarify, I keep saying the word side yard. It's technically a front yard setback because River Bend, the unbuilt portion, is along that northerly property boundary. And so that constitutes a front yard. So the existing house does not encroach into that side yard, into that front yard setback. Therefore, it's conforming. But what they're proposing is to move the house into that setback area to make it non-conforming. So that is an intensification, if not a new non-conformity in that area. And that non-conformity is going from a single-story small garage to a 33-foot house, 33-foot tall house. That is a significant change from existing conditions. I've heard tonight that this is necessary to get it out of the velocity zone, but that's why it's being put on piers. We're putting this house on piers or stilts to avoid flood damage, to avoid flooding in the basement. So I don't understand why you couldn't just raise the house in its existing footprint, which is what my clients would like to see. That would be a solution that wouldn't require the zoning relief that is at issue and is contested here tonight. I want to address the height issue. So I'm glad that the applicant provided the revised height calculations yesterday. It confirms what we thought, which is that the height of the residential structure is proposed to be increased. But it raises a question of whether the existing height of 31.5 feet is really protected as a pre-existing non-conforming structure. What's important, the way this works is that is a protected grandfathered non-conformity if it existed lawfully before the zoning changed to impose the 30-foot height requirement. I don't know. I haven't had time today to research the history of the 30-foot requirement. I don't know when that third story was built. But I would suggest to the board that this is imperative, because if that was not lawfully constructed, let's say that third story was an addition. If that third story was not lawfully constructed because at the time there was a 30-foot height restriction, then that doesn't count as a grandfathered nonconformity. So therefore, building a house that's 33 feet tall, if that's what it is, 33.8, that is a new nonconformity that would require a variance. So I would respectfully request that the board ask the applicant to provide the history of that third story. When was that put on? Maybe it's always been there. We just don't know. But that should be determined. That should be clear in the record. It shouldn't be that difficult to find out when that was established. And if in fact that was always there before the 30-foot height requirement got into place, then that's fine. Now we know it's not a new nonconformity, but what they're doing is increasing it, intensifying that nonconformity. The Attorney Singer and the engineer made some reference to 10 years, that this is grandfathered because it's been there for 10 years. That's actually not the correct test. That's a different provision in the Zoning Act, Chapter 48, Section 6. Again, the way you determine if a nonconformity is grandfathered or not, a dimensional nonconformity, is you look back at what the requirement was when the nonconformity became established. So again, if that addition, let's say that addition was put on in 1950, if Harwich didn't have a 30-foot height requirement in 1950, it's grandfathered. But if that addition was put on in 2004, and the height requirement predated it, then that's not a lawful addition for purposes of zoning. It doesn't have to be taken down. It doesn't mean, so they're correct, after 10 years, the building inspector can't force them to take it down. But that doesn't establish grandfathering for purposes of extending a non-conforming structure. So again, we'd ask that the applicant provide the evidence of when that third story was put on and what the zoning required at that time. So just in conclusion, we feel that there are 3 jurisdictional issues that prevent the issuance of a special permit. There's the increase of the setback nonconformity in the side yard. I keep saying side yard. The front yard that's adjacent to the paper street. The project will not decrease a setback nonconformity. Simply, it's not shown on the plans. And the project, the height issue is an open question. And at the very least, we're talking about an intensification, an increase of height in new areas within that front yard setback. And that just can't be countenanced under 48 Section 6, and it can't be allowed under your bylaw. So for those jurisdictional reasons, we'd ask the board to deny the application. Before you do that, I think you should give the applicant the opportunity to provide the evidence on the third story. And we'd also request that this hearing be continued so that if we get past these jurisdictional issues somehow, we would like to make a further argument that the special permit can't be granted because the project is not is substantially more detrimental than the existing conditions on the site. Thank you.
Thank you. So if I heard you properly, your argument, one argument is the fact that the current nonconformity of a building height, the existing home at 31 feet, that even though it may be over 10 years old, and even if it was given a proper building permit at the time of construction by the town, that you're saying that it can't be considered a pre-existing nonconformity.
Right, that's correct. The 10-year provision is basically a bar from the town, the building inspector, to force that addition to be taken off. So basically what that 10-year provision says is if I build something with a building permit, I build a structure, and it doesn't comply with zoning, and 10 years goes by and no one complains about it, I get to keep it. But that doesn't mean I get to then add on to it, or in this case, tear it down and build a new one. So it doesn't become a launch pad to then extend a pre-existing non-conforming structure. It is a protected structure, but you can't then take that and build onto it. There's case law to support this, and I can easily, after tonight, I can supplement my memo and send that to you if you'd like.
Okay, thank you. Are there anyone else that wants to, in the public, speak in this, regarding this case? Okay.
Mr. Chairman? Oh.
If you do, please. And if you could just state your name and your residence in Harwich.
My name is Mary Lou Cahalan, and I live at 21 Riverside Drive, and I have a lot that goes down to River Bend, just opposite 11 River Bend. And, one thing about the existing house, it's a structure that we know. We don't know, about this new structure and its location and, how it's going to affect different people, Maybe the people closest to the water, like Ginny Funk and Frank Doyle and Paul Kelly, Maybe all those people will be affected more. But one of the things on the new house was the decks that are not attached to the house, so they don't even get counted as part of the structure, so they wouldn't be in the square footage. There's just a lot of things about this that, I know that talking about the Herring River study, nobody seems to mention that. And the town paid like $70,000 to have that done. And we heard a report on that at one of the Conservation Committee meetings. And they didn't seem to be fazed by it, that there shouldn't be more structures in the water. So it's hard to be heard. That's how abutters feel. It's hard to be heard. We're all taxpayers, and we've been there for many years, and love our neighborhood and the river. Thank you.
My pleasure, thank you. Attorney, would you like to address comments from the two abutters that spoke, as well as from Attorney
Yes, thank you.
Hill?
Yes, thank you, and I appreciate the comments. And I have just four, I think, brief responses. As far as, not in order, I guess, or maybe in reverse order, excuse me, the proposed decks, while for structural reasons they're built as they're proposed, they have been included in site coverage. So the decrease in site coverage that we show on this sheet includes the new decks. So they are absolutely included in the numbers. They're not building coverage, obviously, but they are site coverage. As far as a couple times, a comment's been made that the portion of River Bend that's along that runs east-west along the north side of the property, that it's been both in writing and testimony tonight that it's a paper road. Well, I submitted photos to you in the first handout I did. I mean, it's the road that leads down to two driveways. So it is anything but a paper road. It's the second image on the handout I gave you, which I was standing looking towards the water, looking east. So just wanted to comment that it's not a paper road. It's actually a private road that provides access to two different houses. And I think people walk down to the water that way. At the end of the road, I think there's a path. The third thing I wanted to mention is, respectfully, I disagree with Attorney Hill on his interpretation. I think he was missing something. 48 Section 7, I think it's Section 7, does say, or historically said, that if you have a building permit to build a house, right or wrong, after 6 years, that permit can't be challenged and you've got your structure. The original law also said that if you had a structure that was built without a building permit, after 10 years, it could not be forced to be removed. And he's correct as far as that goes. But about, Mr. Chairman, you might remember this better than I. I want to say 8 to 15 years ago. It was a long time ago. They passed an amendment where they expressly noted that any structure that was protected under the 10-year rule was now to be treated as a pre-existing non-conforming structure for purposes of 40A. And that's exactly, so I don't know, we're not saying the third story was built with or without a building permit. We don't know. But we have submitted documented evidence, and of the 2010 Google Earth, and we can give you, it's a little blurry, but we have the 2005 as well. Well more than 10 years, the structure has been there. So it's my opinion that under that subsequent amendment to 40A, that this is a pre-existing non-conforming dwelling, that part, and then the garage itself is pre-existing non-conforming. And the last point I wanted to make is that, again, getting back to jurisdiction, the Harwich zoning bylaw expressly defines both of these structures as residential structures in the definition section of the bylaw and throughout operative provisions. Because they are residential buildings, I think it's very clear that they can be treated as subject to 40A6 and 32554. Now, to Attorney Hill's point, other than trial court cases, we don't have a definitive appellate answer on this, and this may or may not someday be that case. But it is a residential structure, and even the land court judge who thought they shouldn't be said that they might be, and you just have to prove it. And that's what we did for you this evening, is relating to the case law and relating to the zoning bylaw, showing you that we believe that they do qualify. Thank you.
If I could just add one thing, or a couple things, but comparing the new structure to what's there now isn't overly realistic. When the owners first bought it, the intention was to fix it up, but the reality is it's not safe. The basement floods at even small storms, and so they're going to have to take advantage, without this type of relief, they'll have to take advantage of the bylaw that encourages people to lift their houses in the floodplain. And again, that's going to create a structure that's 5 feet higher than what we're proposing, because when you're in the velocity zone, when you're in that high hazard flood zone, it makes everything higher. And also the building itself is a taller building. So comparing that isn't to what's there now. That was the original intention, I believe, but again, it's not a safe structure, and it certainly isn't safe in a building code design flood or a FEMA design flood. It's when that structure takes on a major storm, the other structures in the neighborhood aren't safe because the debris will be everywhere. The other thing that was brought up was that it's closer to the marsh, and that is not the case. But that was the reason for creating the simplified plan that I handed to everybody, because when we're dealing with a small lot with so many issues, I think my proposed plan is hard for people to understand. That's why I simplified it down to just the colors, to show that the new structure is going to be further from the wetland, or certainly or the house itself is, and the deck as well is going to be a little further from the marsh below, and the river, where the existing deck actually hangs over the river, will be back to the seawall in one area, and then most of it gets replanted to the south. And I think getting to the point, it is a goal to get out of the high hazard flood area, even though we're building on pilings, which is to the new building code. This is where it's built, or where it's proposed, could actually be on a enclosed foundation with flood vents. But thinking ahead, he's building on the pilings. There's still other reasons to stay out of the velocity zone, and some of it's the steps going down from being taken out, utilities and other things. Thank you for your review.
Yes, if you have a brief final comment, I would appreciate it being brief, please.
Yes, just a brief comment. The house is 95 years old. It's been there almost 100 years. It was built in 1930. It would stay another 100 years. In the town property record, it's listed as very good condition. So, I mean, it's a structure that's been there a long time, and it's in good condition, except for the fact that the basement has been flooded. Thank you.
Thank you. Any additional questions, comments from you and the board? All right. Myself sitting here, I feel that I personally like to ask for a continuance of the meeting to obtain opinions from town council. Because there are areas here that, quite frankly, I don't have, and again, this is my personal feeling, and other board members here may feel differently, that they're ready to proceed, but I'm not, okay? And I think to confirm the status, first of all, using the setbacks of the garage, and using those setbacks for making a pre-existing nonconformity setback for the new home, I just need to get that verified. My personal kind of gut feeling is the fact that it can be used, but I'm unsure. And I think I need to hear from town council their interpretation. Because in other cases we've had, in looking at garages as an accessory structure, at times we've had to actually have a variance in order to, raise and replace a garage, which I didn't understand myself at that point either, okay? So I need to get that clarified for myself from town council. The other thing here that's been discussed is regarding the building height. The issue's been raised and discussed, debated by two, experienced and competent attorneys. And I'm not ready myself to make a decision as to which attorney is correct. I personally thought in the past, over 10 years, it became a pre-existing nonconformity. But the question's been raised whether or not that only exists for the fact that the town cannot have the homeowner remove a height. And because of that consideration, I would also like to have town council weigh in. Any thoughts on that, gentlemen and ladies?
I'd agree, Brian. I think there's,
Concur.
Okay, and I apologize for saying gentlemen, I'm so used to having just gentlemen here for so long, it slips out. So my apologies to the public and our new board member. I would like to get that defined better. And if we're going to ask for continuance, I will not send in a request from the attorney for a town council for a couple of days. I would like to see renewed briefs on these points, or other points you want to make, from both Attorney Hill and Attorney Singer, so that you can clarify your positions on those points at least, or another point you want to make regarding this, so that I can prepare a proper request of town council for their opinion on the case. Now, of course, town council will get all documentation involved in this, okay? Including the updated documentation and so forth. But that's my consideration, and I do believe at this point, requesting that the applicant would agree on a continuance, and that we could go forward with continuance at a subsequent meeting.
Well, let me just, since my client's here, let me turn around and just get a nod from him. A nod, are you okay with a continuance?
it would make sense.
Then yes, we are.
Okay,
Just didn't want to speak out of turn.
thank you. So,
And, Mr. Chairman, I will provide some additional documentation to you.
okay. And Attorney Hill, would I be seeing additional documentation from you as well?
Sure, I'd be happy to address those issues. How much time do I have?
Well, you got this first letter to us in a day, but perhaps, that was 7 pages. I would like to think, I probably won't approach town council till, is Monday would be fine for everybody, or do you need more time?
I'd prefer,
Monday's fine.
I'd prefer Tuesday.
All right, so I won't be sending anything to town council for requests until Wednesday next week.
Great.
Okay.
Okay, so if you could direct your letters to Rachel, would appreciate that. And at that point, then I'll draft a request for town council's opinion. And before I send it off, so that I don't miss anything, I will forward it to both attorneys to make sure that you feel that I'm requesting the opinion appropriately. You may not agree on the subjects, but I want to make sure that there's an agreement that it's being requested thoroughly, okay? All right. So, I'd like to make a motion to the board that we accept the applicant's approval to continue the meeting.
What would that day be, sir? What
Well,
day?
right now, we're going for May 28th.
28th? Okay.
I don't think we need to sign a form tonight, because it's going to be the next meeting.
I think so. Yeah, I
Okay.
think you're right, yeah.
All right,
So, okay.
we can do that. If there's some reason we can't continue, we have to continue past, May 28th, at that point, we can sign that other form. That'd be fine. All right. All those in favor of the continuance?
Aye.
Okay, we have a continuance, and I appreciate all the time and effort from everyone here tonight regarding this case, and I hope you all understand the viewpoint to continue to get further information from town council.
Thank you for your time.
Thanks.
Thank you.
Real quick, I need a second to that motion and revote. Al, second. Okay, all those in favor? Aye. Okay, it's approved again.
Thank you.
Thank you very much. Oh, it'll just be a minute till I get, this 121.
Okay, case number 2025-16121 Belmont Road. Property is owned by Bonita Eva.
They pronounce their name Bondi.
Bundy? Okay. The owner of property located at 121 Belmont Road, Assessors Map 3, parcel 82-51 in the RH1 zoning district. The applicant seeks a special permit from 325-54A, or as well as 5, non-conforming structures and uses, and 325, attachment 2, table 2, area regulation to raise and replace existing non-conforming single-family dwelling and garage pursuant to the Harwich zoning bylaws of 325-54, and Mass General Law 40A, Section 6. Okay, the Health Board had submitted comments indicating the full compliance septic system with 2 compartment tags must be applied for by the licensed septic installer prior to the building permit sign-off. The planning department submitted comments indicating it had no concerns, and a letter to the board granting a special permit was received from Denise and Bernard Gamache of 29...
Opposed.
Opposed, excuse me.
Thank you.
Big difference. 29 Kelly Road, abutters of 2121 1, Belmont. No other comments, no other department, the butters were received.
At least not received at the time that I wrote this, we did this later, early today. Okay, I'd like to ask the applicant to representative to introduce themselves.
Thank you. Bill Riley from Chatham, here representing Eva and Les Bondi. My client's, Mr. Bondi anyway, works for a defense contractor in the Persian Gulf, so they're not able to be here. The family's been there for about 15 years, and they're planning on spending more time back here. And this property's been in Mrs. Bondi's family for quite some time, and over the years, the ownership has fragmented to an extent that they had difficulty agreeing to properly maintain the property, which is why it looks the way it does today. Les and Eva bought it several years ago, and it took them a while to work up their house plan, but they believe that their proposal will represent a significant upgrade to the property itself, of course, but hopefully will enhance the neighborhood as well. I mean, the proposal, I mean, you have the building plans, and I'm sure you've visited the site. So right now, the existing coverage of the structure is 11.9%, and they're increasing it to 27.4%, where the maximum is 30%, as you know, in this zone. Site coverage is going from 18% to 34.6%, with 35% is allowed. On the south side of the building, there's a encroachment in the setback, which is being reduced. So it's going from 9.2 feet to 9.3 feet, as required by the bylaw. Also, the garage, which encroaches on the rear setback, is being removed and not replaced, so that the setbacks on the other sides, both the street setback, the rear setback, and the sideline setback on the north will all be conforming. The proposed house is substantially larger than the existing structure, and there are other structures in the neighborhood that are, as you drive south from Route 28, which are very similar in size. As you get closer to Lower County Road, the buildings tend to be more like cottages. So I think that this would be a great addition to this neighborhood. The building will not exceed the building height. It'll be 29 feet 11 inches, where 30 feet is allowed. And so I think that in terms of, is this building going to be substantially more detrimental to the neighborhood? We feel, the applicants feel, that not only is it not substantially more detrimental than the existing structure, but we believe it constitutes a significant upgrade to the property, which the applicants believe will enhance the value of the properties around it. Replacement of the structure will not cause or contribute to any undue nuisance, hazard, or congestion, as it's just going to be a single-family residence. Replacement of the structure will not increase any of the existing nonconformities, and it's going to reduce, as I indicated, one of the existing nonconformities. There is an intensification of use because the building is going to be larger on a non-conforming lot. And I think that, under the Gale case and the other cases that deal with special permit request, where you can find that the building is not substantially more detrimental to the neighborhood, this property would qualify for a special permit. I think that would be my presentation, and be happy to answer questions.
I'm going to ask a few questions, and I have some others now, but after I ask my first few, I'm going to turn to the board and see if they have any questions first. But what is given approval, what would be the time frame for construction?
They would not begin their construction until September. As they say, the Bondis live most of the time in Qatar on the Persian Gulf. I spoke with the architect today, and they have not yet engaged a contractor. I don't believe the full construction plans are ready yet, so I think it would be unrealistic for them to really attempt construction before June 30th. So I believe they're not going to attempt to do anything until after Labor Day.
Okay, all right.
And I think the lot is large enough, to maintain all the construction vehicles on their property.
Well, that was my next question. Thank you. All right. We don't need to get into the discussion now, I don't think, but I think the location may be one which will have impact on seasonal traffic, and if we do an approval, the June 30th of any year to Labor Day might apply for this property.
I would agree.
Okay. And the trailers here now is going to be removed?
Yeah, of course, yeah,
Okay.
yeah.
What is the building coverage, what is the building square footage coverage of the current main dwelling?
The proposed building coverage is 3,660 square feet. That's what's proposed.
Okay, I didn't know so the existing house is, gather, it's probably
Well,
1,800.
the existing house is, building coverage, I don't know the area, but it's I looked in the assessors, and it's like 1,200 square feet,
Okay,
something
all right.
like that.
1,200 square feet, okay. And could you tell me, I think the habitable square footage of the existing dwelling versus what's being proposed for habitable square footage of the new house?
Well, I think because it's a single-story structure, I think the building coverage is the habitable area as well, about 1,200
Okay, all right.
square feet. I think the habitable area is will be,
Not including the ADU, I'm saying.
right, not including the ADU, would be around 6,800 square feet.
I do have some more questions, but I just want to offer it up now to the board. Tim?
I have no questions.
Just to clarify, it's a request for raise and replace, and the only nonconformity that I'm looking at or seeing is that side yard setback. That's actually becoming slightly less nonconforming? Is that accurate?
Correct.
Or is there any
Well,
other
there's a-
reasons for it to be nonconforming?
The existing garage is non-conforming to the rear setback. That's being removed and not being replaced.
So that doesn't affect, the request for us today, the only special permit requirement, it would be just strictly for the side yard?
That's correct.
No other questions?
No?
My only questions are, the square footage of the current property,
That was approximately 1,200 square feet.
1,200, is going to go to what?
About,
Well, 3660,
Council.
oh, I'm sorry, excuse me.
yeah, about
Apologize.
68, the total living area in the building's about 6,800 square feet, looks like.
How's that
The
possible?
properties that are in that neighborhood surrounding that home, those properties are approximately what size in comparison to the property that would be built?
Well, the properties that are immediately abutting the property were around 1,700 or 1,800 square feet. Most of them are single-story buildings. As you drive south from Route 28, approaching the site, there are many much more substantial properties. It's just that the further south you go, the more, I think they were more like summer cottages built back in the 40s and 50s. And I think my experience, not only in Harwich, but in our other surrounding towns, is that when those are renovated, they're raised and replaced with larger structures. So I think that this is, for a family like the Bondys, with their children, and their plan to live here more or less full-time. They've been out of the country for quite a while, and they are really looking forward to having a comfortable home. I think that the enhancement that this property will bring to the abutters, even though this property is substantially larger, I think it's a tasteful design, so it's not going to overwhelm the abutters' properties. But I think it'll enhance the value of the abutters' properties because when the abutters go to sell their homes, if they ever do, the prospective purchasers would see sort of what the opportunities are, and it will further enhance their value and provide greater tax revenue to the town. So I think that while it is a large change, I think the design keeps it so that it fits in to the extent that this larger home will, because again, it's not going to dominate the neighborhood because of the traditional design of the roof, to tell you the truth. My feeling.
All right, thank you for the information.
I didn't mean to. John?
I think I'm trying to get back to your comment, Brian. Is your concern the 25, in excess of 25% increase?
Oh, actually,
in
no,
having-
I'm not concerned about that, because, well, regarding that bylaw that requires 25% increment increases, I don't think it's on residential properties, I think it's in conflict with the Gale case, and we've been pretty much ignoring that.
Well, the language in the bylaw is you can't increase greater than 25% after the issuance of the special permit. That's what the section in the bylaw says. So it's not a 25% limit.
Oh, that's
your
a
grant.
clarification.
Yeah, the
Over a
limit,
10-year period beginning at the date of the issuance of the permit.
it has to do with doing additions after you have granted the increase.
Regardless, it's a part of our bylaw, which I feel is in conflict with Gale, and so it's normally,
Well-
we've never really, at least in recent times.
Yeah, see, so the replacement, what it says is the replacement structure may not increase the habitable square footage of the structure by more than 25% over the habitable square footage of the existing, over the 10-year period, beginning on the date of the issuance of the special permit.
My question, and I asked that question, John, is, and I'm gonna get back to it, is I'm a little concerned regarding the size of this project in relationship to the neighborhood. That's one reason why I want to gather information, but I also want to hear from, if there's any abutters or people that like to speak before I comment more. Well, any questions?
No questions.
Mr. Chairman, if I could just point out, the way the designer provides the room, if you look at the design,
Yes.
he uses dormers rather than having a full two-story like a colonial with a hip roof, so that, so I think that tends to minimize the impact of the larger structure.
No, I appreciate that comment. Is there anyone in the public here that would like to speak in regarding this case? Yes, sir. And if you could just state your name and...
Yes, my name is, technically I'm Bernard Gamache. I go by Dennis, but legally. And I'm here to oppose the issuance of this permit. I own the property at 29 Kelly Road. Excuse me, I'm a little nervous.
What road, sir? I'm sorry.
I own the property at 29 Kelly Road.
Okay, thank you.
My property is on the corner of Kelly and Belmont, and abuts directly to the 121 Belmont. The south line, or the south property line of 121 Belmont is my north property line. So we're direct abutters. And it's the entire line, the entire length of the property line. You've got my letter that I sent in, because I wasn't sure I'd be able to make it here this evening. My main concern is the setback to my property. The house that's there now is a single-story house. There's a fence between us, and we see very little of the house. We see from the roof line up. The structure that's there is probably 14 feet high at the peak of the roof. And the peak of the roof, what the part of the roof that is on is on the 9.2 foot property line is the lower part of the roof. In other words, the roof slopes towards my property. So the wall where the roof ends is at the 9.2 slot, and that part of the house is only 10 feet high. And then the roof slopes up and goes to 14 feet as it gets further away. Am I clear?
Yes.
Because I could draw a picture if that would help. But anyways, the way they're proposing to put the new structure on the house, on the property, there will be a full 29.9 foot wall at that location. So I'm going from looking at a 10-foot high wall to a 29.9 foot wall within 9 feet of my property line. That to me is a nuisance. And whether it's a nuisance to the whole neighborhood or not, I don't know, but it's a nuisance to me. I'm gonna throw a wrench in a monkey wrench here. I flew in last night. I didn't get in till midnight last night. I went out there this morning because I thought the 9.2 foot sounded funny. I've lived there for 14 years. I actually went over with a tape measure and measured the distance, and that distance is more like 13 feet. So now there is a conflict between what's on the drawing and what I physically measured. And so it looks to me like they're trying to tell you that it's a 9.2, and they're going to lessen that or it's 9.3, and they're going to lessen that to 9.2, looking like they're the good guys, and yet it's a current 13-foot setback, and they're going to make it 9.3. So I have a very big concern about that. They had a surveyor out there earlier this year, because I saw it on my security cameras. And when he finished, there were no stakes put in. Normally, when somebody has a lot surveyed, they put stakes in. I want to say that that's because they realized there's a problem here and they didn't want to make anything obvious, but I don't know. There is it's very easy to survey this lot and measure because there's a land court stone between the two lots out by the street.
Yes.
And on the other side of my lot on Kelly Road, there's a surveyor's stone. So it was very easy for me when I erected my fence to measure back according to the plot plan and get the corner of the lot to make sure my fence was on my property. And that's where I measured this morning from my fence to the house. And my fence is probably 6 inches on my property, and that's why I'm saying it's about 13 feet. So I have a real concern there, and I think something needs to be clarified. Either some stakes need to be put in and surveyed so we can verify this, because I'm also concerned, this lot, I've owned my property since 2014. The owners of that particular property have been out of compliance with regulations for the town several times. The first time was they had a storage container parked in the front yard for months and months and months, until the town finally made them remove it. Currently, they have a trailer parked on there that's been there for years, and there's somebody lives in it. And that's not according to code either. So I'm very concerned that because they haven't paid attention to any zoning regulations before, why are they gonna pay attention to zoning regulations now? They're putting a huge structure on this lot. It says right in the application, that if I understand it correctly, if they were to apply for a building permit to build this house on a new lot, that lot would have to be 40,000 square feet. This lot is 16,740 square feet. They're cramming this house into this lot, and it probably will be, as far as I know, the only non-conforming property in the neighborhood. Excuse me, I gotta get my thoughts here. You asked the question, I mentioned in my letter about the surrounding houses. Every house that abuts to that property is a single-story house. Every single-story house that's on that, or those properties are all conforming. And this is the only non-conforming property in the neighborhood. The house directly behind that abuts it on the east side is a 2-story house. But it's well conforming, it's probably 40 or 50 feet from the property line. So I'm concerned about the size of the house, but I'm mainly concerned about the setback and having to look at a 29 and 0.9 foot high wall facing it, because that wall is I'm sorry, I can't think of the name of it, but it's a full wall, it's not a slanting roof. It is a full wall right there. I think I've covered all my points, though. So thank you.
Yes, our pleasure.
Excuse me?
Our pleasure. Thank you for speaking.
Thank you.
Is there anyone else in the public that'd like to speak regarding this case? Okay. So I'm going to ask this board for their additional comments or questions. Aside from the proposed ADU cabana, I spent a lot of time in the neighborhood, going up and down the street. In my opinion, in my personal opinion, not as chair, but as my opinion, the proposed new construction of the main dwelling will impact not only the immediate butters, but will significantly alter the character of the neighborhood. And therefore, I feel this construction will be a substantial detriment to the neighborhood. Most of the homes in the surrounding area, not just the abutters, because I realize Ms. Camachi's, for him, it would be a hardship, but we have to look at substantial detriment, something that has to affect the whole neighborhood.
Well, if I could,
Let me just finish my thought, then let you jump in, of course, Attorney Rao. But in my opinion, I feel the fact that the size of this dwelling, as well as the height, going to just under the 30 feet, will impact the character of the neighborhood, and then in my opinion, it is a substantial detriment.
well, a couple of things, Mr. Chairman. I guess the criteria that, your bylaw contains has specific numbers to which you can build to. And Mr. Gamache is wrong on a couple of points. We have a stamped, surveyed plot plan by Dan Ojala, who's not only a professional land surveyor, but he's also a professional engineer. So I'm confident that it's correct. If you look on the site plan, in this corner, you can see how they call out the land court bound. It's not on the property line. And so if Mr. Gamache is measuring from that, that's probably how he got the impression. Also, it's not a vertical wall. It's a slanted roof. There is this bottom one, this is the right side, what he would be looking at. So, yeah, so he's gonna have a gable end that will project over the fence, but the rest is a roof that slants away from his property. So I think that I guess the question is, and I appreciate your concern, does that mean that even though there are other two-story houses in the neighborhood, including the one that's directly behind us, that if you want to have a two-story house that's going to look over Mr. Gamache's fence, that's going to have a negative impact? I don't see, the job for you is it substantially more detrimental to the neighborhood? And if you just walk around the houses immediately abutting this house, yeah, they tend to be like cottages, though the one behind us is a two-story house, and down Kelly Lane on the other side, there are two-story houses. But as you approach this property from Route 28, you have older homes that are very substantial. They're all 2 or 2.5-story homes. And so the fact that once you get past this house, there are more cottages, I think it's unfair to say, well, because we have some cottages right here, that, it's going to be substantially more detrimental to the neighborhood. It might change the neighborhood, but, when you look at what's there and what's proposed, I think that, to say that it's substantially more detrimental because it's larger than the houses that immediately surround it, I think is unfair. I mean, we have requirements in the bylaw, all of which are met, and although the height is 29 feet 11 inches, I understand that, but they're using dormers rather than having a vertical wall with a plate line, where the windows, second-story windows are above the plate line. So I think the architect has worked hard to provide the Bondi family with the room they need inside the house, while not trying to overwhelm the property. I mean, the building coverage is proposed, at 27.4%, so, 2.5% below what would be the maximum amount allowed. So I think that Mr. Gamash's concerns notwithstanding, this is a home that in 10 years is going to be one of other larger homes. Because as much as sometimes we lament the fact that cottage areas are leaving us, and they represent what we had for so many years, the reality is that this is how people enjoy their property, how their families come here and are able to stay and live year-round. I mean, so it's not a cottage, they're living year-round. Mr. Gamache apparently lives somewhere else, he comes and stays here, in a smaller home for the summertime. These people, they're coming here, they're gonna live here. And they haven't had control of the property until very recently, because the ownership was splintered among several generations of family members over whom they had no control. They all had ownership rights, so they couldn't say, oh, you can't do that. They're all what we call tenants in common. And every tenant in common can basically do whatever he wants on the property. And so it's been an embarrassment to them that somebody lives in that one of their cousins or relatives lives in that trailer. But it's going to be cleaned up, and when it's done, this is going to be a huge improvement for the neighborhood. It's going to increase the value of all the properties around it, and I think that, so this is the side of the house that faces Mr. Gamache. So all he's going to see over his fence, which is very substantial, is two windows and a slanting roof going away. And so I think that his concerns are misplaced. There's always the fear of the unknown. Oh, there are going to be changes here. Well, there are going to be changes here, and they're not limited to just the Bondi house. There are going to be other properties that are going to be changing too over the years. And so I think that where we come in, although we are 29 feet 11 inches, but we're not pushing the envelope on any of the other parameters that were allowed under the bylaw. And so when you look at what's there, because the standard is the proposed structure substantially more detrimental than the existing structure. And the existing structure is a wreck. And it's not the Bondi's fault that it's a wreck. It's just the family, splintered as it was, has allowed the place to go to rack and ruin. So the Bondis are coming in, they're stepping up, and they're gonna change things, so it's gonna be the pride of the neighborhood when they're done. Beautifully landscaped, and set back from the street. It's not crowding the street at all. So I think that, while I appreciate Mr. Gamash's concerns, I think that the, again, substantially more detrimental than the existing structure. I mean, they worked really hard with their architect to come up with this design, and it's not a design that has two-story vertical walls. I mean, the walls are one story high, and then dormers and slanted roofs. So I appreciate your concern. I just don't think that because this building is larger than the buildings around it, that it's substantially more detrimental to the neighborhood than the existing structure. Thank you.
I appreciate those comments. Can I make one brief comment? We're still in open session, so yes, you can.
Okay. Sorry, I'm not sure it's this gentleman's name, but he stated that when you come down Belmont Road off of Route 28, there are several substantially large houses, and he's right. But they're on much, much larger lots than this house will be. They are on probably 1 acre lots. And so I don't think that's fair to compare those houses with this house. The other concern I have is I would be very hard pressed to see how any construction vehicles will be able to be on that site during construction, because every part of that lot will be under construction, including the front yard, which is where the septic system is supposed to be going. And so I don't see how that house can be constructed without affecting the traffic on Belmont Road.
Just to quickly address that, typically because of that location and because of the traffic, particularly seasonally, we would be restricting, exterior construction during a time frame.
I understood that, and that was something I was gonna bring up, because
That isn't,
all those houses in that area that he refers to, that I refer to as the single-story houses, those are all seasonal houses. People come there for the summer and during the winter. I mean, some people use them, but they're not full-time residence houses.
whether it's full-time or part-time, it's not our
We still
concern.
pay property taxes, I agree.
No, but it's still the existing
Yes.
homes.
I have pictures if you want to see. I don't know if that would help or not.
If I could respond, with regard to the size of the lots, your bylaw uses a percentage of coverage,
Yes.
which is how you deal with different size lots, because you're limited to a certain percentage. Doesn't matter what size lot you have to meet that percentage.
Correct.
And the smaller the lot, the smaller the house.
Yes.
So, and as a construction note for whatever that's worth, right, the septic system is proposed to be in the front yard. The septic system goes in last, so, I mean, there's plenty of room on the property, because the house is set back 41 feet from the street. And over on the ADU cabana side, the cabana's gonna be the last thing built also. So there's plenty of room on that side. And right now, that part of the lot you don't see the full size of the lot because it's so heavily treed. But a lot of those trees are gonna be removed, so there'll be plenty of parking space. And the property's gonna be beautifully landscaped. And it's gonna be a credit to the neighborhood.
I have no concerns regarding parking for the site on construction, none whatsoever. That's not a part of it. So,
Mr. Chairman, may I ask a question of the butter?
of course,
How far is your setback? I guess it would be on the north side from your lot line. Where
I'm
your
sorry?
lot line is, how far is your setback? Your side yard?
Okay, so my house is at an angle on the lot, so the point of my house, the rear, western part of my house would be the closest. I would estimate, I've never measured it exactly, but it's 30 to 40 feet.
Thank you.
Yes.
Right, so in other words, the houses are 40 feet apart. sideline setback here, requirement is 15 feet. So if the houses are more than 30 feet apart, the goal of the bylaw is accomplished.
Mr. Marsh, could you have another comment? Because I don't want to get in debate back and forth here.
No, I understand, I understand. When I finished before, I forgot to state my ultimate goal here, and that is, I believe, if I read the zoning requirements correctly, it says if you're gonna take down a building, if you're gonna raise the building and build a new structure, then you have to conform to all setbacks. And
All conforming setbacks, but if it is a pre-existing non-conforming setback, you have to at least conform to that, or you are allowed to intensify it under the Gale case, so they could actually go closer if we felt it was appropriate.
But in fact, we're reducing,
Yes,
we're increasing the setback.
I have no concerns on the setback issue that they proposed. Okay. Any other comments or questions to the applicant this time?
No questions.
No questions.
No, I just, in all deference to you, Brian, I think, you know, the size of the neighborhood is the question here, right? And I would agree, there's really no character to this neighborhood. If you consider Belmont to be the neighborhood, as you drive down, it changes significantly 2 or 3 times, and as you get closer to Lower County and Old Mill Point, you know, you go back again to large houses, so, personally, for myself, I think it is a large house, but I think
Okay.
he's complied with the applicable zoning rules and would not be a significant detriment to the neighborhood.
I appreciate that. Al, anything further?
No, I'm struggling with the neighborhood size of the house, but I have no further questions.
Carolyn?
Well,
I don't have any questions. I too am concerned about the size of the house and the fact that it's going to be raised. I think it would be nice to see the setback enlarged in deference to the fact that the rest of the houses in the neighborhood are conforming. And I am concerned about the size of the house and the fact that there are larger houses down the road. To me, makes no difference whatsoever. Neighborhoods change from one to another, but to stay within the character of what is that small section of neighborhood, I think is actually important, personally.
Well, I think not only, as John pointed out, not only do you have large houses between this house and Route 28, but when you drive down to the end, you're at the Belmont.
I understand that.
And
That doesn't change my opinion.
Mr. Chairman, I do have another comment. I was going to save it for this board, but I feel compelled to follow the statute. I feel compelled that I look at the proposed finding of facts and says proposed dwelling will be conforming to all setbacks except, which will remain non-conforming. It'll be reduced in non-conformity. The building height will also remain conforming with the proposed height being proposed. And to John's point, there are big houses up and down this street, and the closer you get to the water, the bigger they are. And I think it's a bit naive if we were to assume that they're never gonna build a bigger house. And a detriment to that neighborhood is what exists there today. I feel strongly about that.
well, most welcome.
No, I agree with that. I think it's a, large development, but what's to say, like, the rest of the neighborhood's not gonna do it, and how does the board,
Sure.
have the right to say no because it is conforming, or, getting, the non-conformities are getting better in this case.
Okay. There's no one else in the public who wants to speak, I believe, and no questions to the applicant. Getting to it, Attorney Riley, do you have a copy of the report from Rachel?
I do.
All the applications?
I do.
Okay, so we're going
Rachel's
to,
very thorough. Thank you, Rachel.
so rather than me reading this, I just want you to, we're going to look at it, and if you have any any changes and anything that we've missed, anybody on the board, but first I'd like to look at the documentation submitted with part of this application. And you could take a look at that. Is everybody in agreement on the documentation that's been presented, any additions?
I am.
Okay. The next question is regarding recommended findings and conditions based upon the documents submitted as of this date. We all can take a look at that list.
Well, the one change, number 5, says it's non-conforming, existing dwelling is non-conforming regarding the side setback at 9.3. It's actually 9.2. It's changing to 9.3. Other than that, I agree with everything.
Okay. The rest of the board concur?
I do, and I just want to make a point again that this proposal, with the exception of the setback, meets every one of our standards.
Sure. My comments based upon look at the size of the construction, look at the rest of the neighborhood, and have concerns, which I voiced. Okay. And the recommended motions would be, as far as on this, I want to just go over those conditions, that the proposed project, there'll be no demolition or exterior construction or new landscaping between June 30th and Labor Day of any year. We are not quite sure about, I don't necessarily believe the fact all the cars can be parked on that site at all times, so I don't believe we should, any questions on the board on keeping all construction vehicles on the site? I really think it
That should be a requirement on Belmont.
should do that.
I think so.
Yeah, we have no objection to that.
Okay, all right, so that's okay, we'll do that. And the issuance of a special, the issuance of any building permit is subject to the Board of Health approval, and the violation terms, conditions, special permit may be enforced in violation, as a violation of Howard zoning bylaw pursuant to MGL Chapter 40, Section 7, et cetera. So, and based upon that, discussion with the board, and I'd like to make a motion that we accept the documents, findings of facts, and conditions of approval as stipulated.
So moved.
Okay, all agreed. Second by Ken. And we have can I have a vote on that?
Aye.
Okay. So I'm going to vote for it. And I'd like to hear a motion to close the public hearing.
So moved.
Second?
Second by John. All those in favor?
Aye.
Okay. All right, voting on tonight's case would be Al Donahue, myself, Tim Bailey, John August, and Kenneth Dixon. Chair will entertain a motion to close discussion.
Moved.
Second.
Second by Al. I have a vote on the motion to close discussion.
Aye.
Okay. I'd like to have the clerk make a motion.
In case number 2025-16, Eva Bondi. So her attorney, William F. Riley, the owner of property located on 121 Belmont Road, has been granted a special permit from 325-54A, 4 and 5 non-conforming structures, uses, and 325 attachment to table 2 area regulation to raise and replace a pre-existing non-conforming single-family dwelling and garage pursuant to the zoning bylaws, 325-54 and MGL Chapter 40A 6. The granting is consistent with the Dale and in related cases as there will be no intensification of one or more existing nonconformities, no new nonconformities, and no substantial detriment to the entire neighborhood. On a pre-existing nonconforming lot, and the proposed structure will not create an additional negative impact with respect to traffic noise, odor, and congestion. Any relief not expressly granted on hereunto is hereby denied. All work shall be performed in accordance with the plans submitted with the application. Said grant and approval are subject to the following conditions. During the life of the project, there'll be no demolition, exterior construction, or landscape between June 30 and Labor Day of any year. For the life of the, for the life of the proposed approved project, all construction vehicles will be parked on the applicant's property and not in a public street or road. The special permit and the issuance of a building permit are subject to the approval of the Board of Health. A violation of the terms and conditions of the special permit may be enforced as a violation of Howard zoning bylaws pursuant to MGL Chapter 40A, Section 7, and the Howard zoning bylaws as these may be amended from time to time.
Just, I think I might have misheard you, just to make sure that grant is consistent with the Gale and Dietrich related cases, as there will be an intensification, one or more existing non-conformity. I think you said no intensification, so I just want to make sure that's corrected. Okay. Do I have a second for this motion?
Second.
Okay. Any further discussion by the board? All right. Just throwing this out here because I think we, you know my viewpoint here, and I don't know the rest of the board. I didn't know whether or not you wanted to see a straw vote before we have a formal vote, in case you wanted to do a continuance.
Always happy to have a straw vote.
Okay. All right. So I'd like to have at this point, a straw vote before we, and all those in favor?
Aye.
All those in denial?
Aye.
What do you want to do?
Oh, well, that's for a continuance.
Okay. And I think perhaps we can use that continuance for us all to have like any additional thoughts you have like to submit comments. And I will also spend my time going back out to the neighborhood, looking things over and the comments you made about this, and look at the design to see if that impacts my consideration. And I'm sure we all do the same thing. I think it's worth taking another look at this. People have raised some points here, including my own board members, which I feel that are worth my looking at this case again from my own viewpoint as to whether or not this is a detriment. Substantial detriment. And I'll take that time to do that. So at this point, I'd like to continue this meeting. I'd like to have, do that. I'd like to have a motion that we continue this meeting to the May 28th.
So moved.
A second by Ken.
Well, I'm not,
Yeah, we can, you want to go different, you want to,
well, I'm going to be out of the country on May 28th.
okay, so, I think I've got the form here. Agreement for continuance. So this one, we'll sign this tonight, which allows up to 6 months.
Okay.
Okay?
The next meeting after May 28th is June 25th.
All right, and I would request a continuance to that date.
All right, so we don't need to actually sign anything, then do we? Do we?
I mean, you can just to be on the
Let's
safe
do
side.
it. Okay. June 25th, I thought you said, but,
You gotta make a motion and vote.
yeah, I will.
Rachel, are you going to be here May 28th?
I guess we'll see. See what happens.
for me, sir.
Thank you.
Okay, so we made a motion to do the continuance?
No, you need to make a motion and vote.
Okay, and, I'm gonna sign the document. Motion's been made, and I made the motion, second by Ken. All those in favor?
Aye.
Aye.
Thank you.
My pleasure. Thank you, Attorney. Move around.
Can we take a quick break, Brian?
Yes, we're gonna take a little, perhaps an 8-minute break, if that's okay with everybody? Thank you.
Did it get cold in here, or is that just my opinion? Cold. What's going on? I need a coat.
It's very interesting.
Tim, were those yours? You want to take that with your package? I don't know if you saw those. Those both on 121, one we
I
just
do
heard.
have those,
I've got some, so I don't know, maybe they're extras. I've got mine.
must have got mixed up. Thank you.
Cold in here, didn't it?
It is getting cool in here.
It cooled down a little. It might have been the frosty. That's, I actually drove this. I did. I went back. So it's kind of two-story.
I was going down.
You didn't, you go? All done. I know it well. You know,
Hey, Matt? Matt, is there a thermostat in here that suddenly got cold?
well, but they don't.
I haven't sold anything with the DP stuff.
Usually figure we're gone by this time of night, shut the heat off.
Well, no, I think that's it.
I'm sure, yeah, that's it. Energy efficient. I think I believe that too, and falling.
Okay, folks, 1 minute, and we'll start.
On your findings, on the last one, assuming we get to it. On your findings here at the end, refer to the conditions of the special permit. And so it does, this stuff. So I don't know, I mean, I'm gonna make the argument there.
Okay,
Yeah, I just,
we're back.
for the board to remove that or.
All right, case number 2025-17, William R. Glover, through his attorney, owner of the property located at Old Colony Road, assessors map 41, parcel C4A-A, in the CV and Harwich Overlay Zoning District. The application seeks a variance from 325, attachment 2, table 2, area regulation to construct a multi-family dwelling pursuant to the Howard zoning bylaws of 325-52 and Mass General Law 40, Chapter 48, Section 10. All right, the Health Department submitted comments indicating they're in full compliance with the septic system must be applied for by the licensed septic installer prior to the building sign-off. The planning department submitted comments indicating the project would be required a special use permit and site plan review by the planning board. No other comments from the town departments or abutters were received. Like, turn that one off.
Okay,
Good evening.
let me, like to have the applicant introduce themselves, and anyone else is gonna be helping you. Is that the case?
Good evening. My name is Thad Eldridge. I'm a surveyor from Chapin. I'm representing William Glover. He's the owner of the property. I trust everyone is familiar with the property.
You can go visit it real quick.
Yeah. We have an on-site, but I'm afraid that you'd all scatter, so. So the property is in the CV Commercial Village District with 20-foot side yard and rear yard setbacks. We're proposing a multifamily structure, so that increases that setback to 25 feet. The property itself is non-conforming. It has insufficient area and frontage. The existing structure is non-conforming to the southerly boundary, as it is 18.6 feet, again, where that 20 feet is required, and upon the change, 25 feet is required. The existing structure was an office, but has the appearance of a residence. My client has served the community for his career. He's gearing up to retire, and he's been a police officer. He's seen the issues of the housing crisis firsthand. Police departments have issues hiring young officers and keeping those young officers. So he was very excited to review the possibility of a multifamily here, specifically to advertise at the police department and then the fire department.
Is Mr. Glover here tonight?
He is not.
Okay, thank you.
His intention is to redevelop with 4 apartments. There'll be 1 bedroom with the intended renters being single or couples. So the proposal is to add a full second story to the existing building. and then construct a mirror image of that building next to it, connecting the two with a crawl space for utilities, decks for access, and a storage area, which is always needed with rentals. We've called it a bicycle garage because it's so close to the bike path. So the layout is intended to meet the requirements of multifamily housing under the bylaw. The driveway will be reconstructed to include the 6 parking spaces that are required. The septic system will be upgraded to a compliant Title V system, and we've outlined the location of a conforming stormwater system. There's also a dumpster that's been specified on the site that's as far from the neighbors as possible. We took some time to review the project with town staff and the two closest abutters, as they're the most impacted, and then we filed the variance request. The variance request itself is for the southerly extent of the existing dwelling and for the proposed structure where we're meeting the 20-foot but not the 25. Conversations with the abutters are specifically left open, and if there are other neighbors concerned, they're encouraged to reach out and be more than happy to work with them. We know that change and construction can be intrusive. Our original plan included a vegetated buffer along the easterly and southerly lines. One abutter asked for a wooden fence there. We said that's not an issue. I'd also like to be consulted when the HVAC units are going to go in and have downcast lighting. All of these are completely acceptable. The existing building is in good shape. Constructed in 1971, it's got a good foundation, and the setback nonconformity is against the town property. This is the wooded area with a lot of ivy in it. The proposal is to keep that development a little bit further from the neighbors by maintaining this setback violation to the southerly line. So owing to the shape of the property, this is not a deep property. And the position of the existing structure, it is twisted onto the property, and it does have that 18.6 setback. We've proposed that this property is unique. This is also the only property that is between the town-owned property and the former railroad bed, now Old Colony Road, which is a odd 5-rod wide road, or 82.5 feet wide. A little enforcement of the bylaw would involve the hardship that would require the removal of the southerly portion of the structure. That would have to be patched up. Sealant would be applied, but in the long term, that would be an issue with leaks. While this is part of a larger project, it is a line item on the list that could be stricken. This does not substantially derogate from the intent of the bylaw, as footnote 4 of Schedule A specifically states the minimum lot area need not be met for the conversion to multifamily. The project is certainly in line with the public good to provide housing. And the setback violation is against the overgrown area owned by the town. The proposal does meet all the other requirements. If the setback had been against residential properties, I would never have suggested this as even a possibility, but it's against an unused portion of woodland. Town staff has recommended that we visit your board first, and I like that because if we don't get this, then we're redesigning everything. I wouldn't want to redesign after going through other boards. Should you approve the requested variance, we'll proceed with filing with the planning board for a special permit and site plan approval. From there, the Board of Health for the compliant septic system, and then the building department. I'd be happy to answer any questions at this time.
Okay, thank you. Marilyn? Any questions?
No. Thank you.
John?
None at this time.
I have no questions.
No questions.
Jim?
No questions.
Okay. I only have a couple. Just want to check on, I know you have to go through several town departments here, but when do you project you may be starting this project?
Maybe in the fall.
Okay, all right.
It is a busy area of town, so I don't see summertime construction being really viable.
No, we wouldn't, probably we'll discuss that, but we would preclude the fact that any construction should not be done through, June through Labor Day.
That would be perfectly acceptable.
Okay. And I think you should be able to keep your construction vehicles on the site.
On the site or within the road layout in front of the site, which usually that's considered part of the site.
When are you going in front of the planning board? Any idea?
We wanted to get through you first
So
before
you
even.
haven't applied for the planning board?
Correct.
Okay.
If we're successful here, we can take these plans and submit them. If not, we're redesigning so that we meet all of the applicable setbacks, and then
Yeah, I think the whole board, you're aware of the fact that we're just, our decision tonight is regarding the, area regulations and setbacks and so forth. It's the planning board that will be making a decision regarding multifamily. Okay, or other, so
Multifamily
we're
conversion.
strictly looking at that, area requirements. Okay. All right, got any other questions? If not, is there anyone in the public that would like to speak to this? Yes, sir, go ahead.
Good evening. My name is Bob Ruddick, and I live at 16 Oak Street in Harwich Center. I'm a direct abutter. In 3 weeks, my wife and I will celebrate our 50th year here in Harwich. I want to thank Mr. Eldridge, the engineer, for the applicant. He has been more than forthcoming in conversations and in providing us with information about the scope and impact of this project. I'm here, however, to oppose the granting of the variances that the applicant seeks this evening. We're a neighborhood and community of family homes. Most of us have been there for decades, some for generations. An apartment house will radically change the neighborhood. It'll be less permanent residents, up to 6 vehicles on a very small site, 2 curb cuts, and no. And in spite of the good intentions, there's no guarantee that the apartment house will be rented to town employees or multi-year tenants, or prohibition against converting into condominiums or for other uses. A single-family home instead of this apartment house would contribute to the vitality of our neighborhood. Variances, I understand, ought to be permitted when the owner of a property needs leeway to improve the site. However, it should only be given in the context when where it does not have a negative impact on the neighborhood. Chapter 40A, Section 10, in fact says that it should be, a variance should be given only in the context of not having a substantial detriment on the community and the community. In this case, this project is a detriment to the community. We would love the applicant to withdraw this application and instead request a variance, or if necessary, to submit to your board for improvement of the single-family house that currently exists there. But if that's not going to be the case, we ask to reject the request for the variances before you this evening. Affordable housing is a vital interest for Harwich, but it is not going to be satisfied by a 4-unit apartment house packed on a small site, altering our neighborhood community and its character. Thank you.
My pleasure. Thank you for coming tonight and speaking.
I believe there are others here to speak as well.
Is there anyone else who'd like to speak here tonight? Okay, please.
Hi, I'm Mimi Smith, and I live at 35 Park Street in Harwich. And I have a question about how this was developed, this plan. I saw this letter that we got from, with the building department, from, I guess it's from Rachel, to the board. And it uses some it cites relevant sections of the zoning code, 325-54-7. And then when you come before the board tonight, you're not using that, you're using 325-52 and the chapter 40A regulations. But the one that sort of outlined this for you guys is not the right one at all, because it's 325-54-7 is non-conforming structures that are other than single-family homes. And it has a lot less stuff predicated on it. Where the one that I think would fit, which is section 5, would require him to have a special permit to do this. And I think that it's confusing to me to see how certain sections are quoted in one way and then not used in another. So I'm just curious just to know how that came to be and what the difference is. So that was my question.
Well, I don't have an immediate answer for you.
I don't mind
Go ahead.
trying to clarify. So 325-54-7 is referenced because that section of the Harwich bylaw specifically relates to pre-existing non-conforming structures other than single-family and two-family dwellings, which is what the existing structure and proposed structure.
But is it? Because everybody's calling it a single-family, existing, non-conforming single-family dwelling.
What's being proposed, though, is not a single-family.
Right, but it is, in fact, in the commercial village, considered a single-family dwelling. And everybody who signed off on it said, we know that they're going to change a special permit to demolish and replace a pre-existing non-conforming single-family dwelling. And throughout this thing, you call this property that, right up until someone cites regulations, and then suddenly it's an other structure, like it's a barn or a, so I'm confused as to how that.
It is replacing a single-family structure, but it's replacing it with a multifamily
right.
structure.
But when you're replacing it with you're replacing a single-family structure, there are different rules and regs than the one that is cited with just the other.
I understand.
Okay, so I'm just confused as to how that works, because it is indeed a single-family structure. And
Right. On a lot which has zoning regulations that allow for a multifamily construction. So what they're proposing, as far as the use, a multifamily, is permitted with a special permit from the planning board. Okay, and also regulations that govern the amount of bedrooms and so forth, and units that, under the health code and so forth.
right.
Okay, so they have to abide by all that, but it is appropriately zoned for the use they're looking for. The key issue in front of our board tonight is whether or not the setbacks that are being considered, if they're a bridge too far, okay? And that's what's in front of us.
And I understand that, and but I was confused by how the paperwork that went before you is different, in that they're using different code. And also, I know that, that this is sort of increasing the non-conforming, as far as in terms of setback and such, and I know that's a different issue, but that was my question, was about why.
Thank you. No, I appreciate that. Is there anyone else that in the public like to be heard on this? Yes, please.
My name is Molly Bench. I'm a director butter at 22 Oak Street. My questions are, and I also thank the engineer, I had a helpful correspondence with him, as well as someone from the Town Health Planning Board. But I guess one of my questions is, to what extent is the reason for the variance being granted? Because if the town just wants more building anywhere for everyone, great. But if the personal letter we received is a direct abutter, and then what the owner's representative said tonight about needing workforce housing in town, I inquired, okay, will these units be deed restricted in any way to know that that's what's happening? And then if we're giving granted variances because we need more workforce housing, or we need more places for people starting out here or working here to live, let's codify that. And in full disclosure, my first home was workforce housing in a different community, so I'm not opposed. People need a place to live while they start their lives. But the owner's representative has communicated to me that is not an intent or a plan. So if the reason for the variance would be because we need more workforce housing and we are not codifying that in any way, nor that seems to be not a reason to then grant that variance. The owner has a history of developing and selling. The owner does not have a history of maintaining the investments, the properties he has done. So there isn't a precedent of him, or I shouldn't say him, there isn't a precedent of the owner holding, maintaining buildings that would make us think that this one's different, although that has been what's communicated to us as abutters, that this is something he intends to hold. But absent a deed restriction for making a decision based on that, and the owner of the property does not have precedent of holding his developments, that's a hard thing for neighbors to understand as far as what's next. I just think it would be helpful for us to know what the reasons are for the variance being granted, based on the conversations tonight.
Thank you.
All right, good evening. Eben Sullivan, 22 Oak Street as well. I also stand in opposition to this development. I know I'll make it short. You're going on 3 hours of this meeting. Thank you for your patience and your perseverance. I support all of the arguments made. I have no further arguments. I just want to be on record that I also would like to oppose this building structure. In support, too much building, not enough land. Thank you.
Any other comments? Yes, please.
Hi, I'm Brenda Azure, and I live at 28 Old Colony Road. I went to Harwich Elementary. I grew up on the East Harwich on the Harwich-Brewster line. I did graduate from Nauset, so don't hold that against me. But, I moved back 13 years ago to raise my children here in the community. It's definitely, home to me, important to me, to our neighbors, and I definitely oppose this project because it does change the character of our neighborhood, our single-family neighborhood, and with all the great neighbors that I have. So I agree with what's been spoken in front of me, but thank you.
Yes, sir, please.
Thank you, everybody. I'm going to be short and sweet, just to echo my other neighbors here, the abutters. Matt Finkel, 39 Park. Great point. The other gentleman stated that this is really, in my opinion, way too much on a small lot. And it's as really simple as that, I think. So thank you, guys.
Pleasure. I'm sorry, what was your address?
39 Park Street.
Okay. Members, comments? Tim?
No.
Tim, do you have any comments?
No comments.
Any questions?
No.
Marilyn?
No.
John?
No comments. I mean, the only, I guess I do have a comment. I'll put it that way. Have we heard anything from the town? They have no view, or they did not respond?
Didn't respond.
They didn't respond.
Couldn't find them?
And you said that this previously operated as an office?
It had,
Okay,
yes.
like a professional office or whatnot?
Mr. Cahoon was in there. It's my understanding it was a legal office.
And again, not to sway my decision either way, but if they were to do nothing, there's any number of commercial establishments they could put in here with a CV zoning, correct?
There are quite a few, yes.
Yeah, so it's not a residential zoning. I mean, although it is mostly residential, but you got town hall, you have other things like that. I just want to make sure that if they went a different course, it could still be not residential.
Correct.
Al?
I echo John. I have no further questions.
Okay. Yeah, this is a site where proposed building coverage is at just under 13%, where 50% is allowed. There's a site coverage of 48%, where 80% is allowed. So there could be far more extensive developments on the site that would definitely impact the neighborhood substantially more. But we can't make our judgments of what might happen, but obviously, and I just want to reconfirm the setback relief that you're looking for tonight on this?
The rear of the property, so the rear setback, and that's
What's the town land?
abuts the town land.
18.6.
So we have
18.6, okay. 'Cause I wasn't-
18.6, and then the other improvements that we're proposing are stepped back a little, but still,
And that 18.6, that's where 20 is allowed, correct?
20 is allowed under the CV, and then when we change this to multifamily, it's a 25-foot setback.
Okay. All right, so the main impact is with that setback, which is adjacent to the town building. Okay,
And if I could respond to some of the comments.
please do.
The deed restriction is difficult. Not many police officers qualify for affordable housing, which is one of the greatest problems. Under the bylaw, it's not required to have deed restrictions for multifamily conversions. It's the size of the building, the size of the apartments that keep them smallly affordable. There's a bit of confusion with special permits, and there's always confusion with special permits because we call Section 6 findings special permits. They're actually change, alterations, or extensions of pre-existing non-conforming structures or uses, which nobody wants to say. So they get called special permits very commonly. Under Section 9, you have the special permit, which would be portions of the bylaw that certain things are specially permitted, like multifamily housing in this zone. And that is heard by the planning board. So tonight, we are looking at, can the zoning board of appeals find that we qualify for a variance in order to maintain the setback nonconformity to the town-owned property, which is partially developed, but mostly undeveloped woodland. We will be before the planning board. Every neighbor will be notified of that, and they will be able to speak to the planning board regarding the multifamily. But that's not what we're here for tonight.
Correct. Okay.
And again, I open it up to conversation with all the
Sure.
neighbors. I'm very happy to discuss this and hopefully alleviate concerns.
Sir, do you have a copy of the letter from, the memo from Rachel regarding the site summary?
I do, and number 10, it should be variance instead of special permit.
All right, so it, just want to go over now regarding documentation and findings of facts. So the information submitted in the part of this application regarding for finding, for the document submitted, it's on that page 3. Applications and hearing documents included, and the board, and as well as the applicant, want to see the fact that we're all in agreement, that we have all the documents, correct?
Yes, you do.
Okay. The next question is regarding recommended findings and conditions based upon the documents submitted in this application, and discussions, the findings of facts discussed tonight. I don't see anything further needs to be added to that. Do you, as an applicant?
Number 10, he stated needed to be modified. It's not a special permit they're requesting, it's a variance.
Yes, right, Commissioner, there should be a, that's a variance.
It's just muscle memory.
Yep. Thank you. You're absolutely correct, I missed that. And regarding motions for this tonight, would be the standard date situation, the June 30th through Labor Day. The issue of the building permit is based upon subject to special use permit and site plan review by the planning board, and the violations in terms of the conditions of this variance would be enforced under the violations of the Harwich zoning bylaw pursuant to GL 48, section 7, etc. We all in agreement on those conditions? Okay.
Aye.
All right, are you fine with that? Okay.
Absolutely.
All right. So let's make a motion, we accept the documents, findings of facts, and conditions as stipulated,
As amended,
as amended, correct.
I move that.
Thank you for that. Ken's always my go-to guy for, these little things of order here. And I'd like to have a vote on that motion, please. All those in favor?
Aye.
And all those opposed?
Aye.
You opposed?
No.
Okay, okay, I didn't hear a vote from Maryland.
I didn't think I was able to vote.
No, you can.
Okay.
Yeah, it's when well, you can't vote is when I first assign people at the end. So all these motions, you can vote.
Thank you.
And then then I'll be assigning members to vote on the application.
Great, thank you.
Okay. So that's all in favor? Okay. And I'd like to have a motion to close the public hearing.
So moved.
Okay. Second by Al. And all those in favor of closing public hearing? All those in favor? Aye. Okay. All right, so voting tonight on this case would be Al Donahue, myself, Tim Bailey, John August, and Ken Dixon. I'd like to have a motion to close discussion. Have a second?
Second.
Can I make one more comment, though? real
Yes, we haven't voted yet.
I think in deference to the comments from the neighbors and everything, just to, from my perspective, on a purely zoning question, given that it's a CV zoning district and someone could easily open a small restaurant or some other small business in this place, I think the concerns are more appropriately expressed at the planning department for the conversion, where
Yes.
there will be another permitting process. But strictly on a zoning perspective, I just want to make sure everybody understands where my vote's coming from, that I think, given the zoning district that this property's in, I don't see a lot of reason to disapprove this. But I do see valid concerns in the planning process.
Absolutely. If this was a residential lot, which only required, well, for 30% coverages and so forth, it would be a different story. Okay. All right, so, the motion's been made and seconded to close discussion. All those in favor?
Aye.
Aye.
And Chair will now entertain any further discussion by the board. Hearing none, I ask the clerk to make a motion.
Case number 2025-17. Over. Thaddeus Eldridge. The owner of the property located at 33 Old Colony Road. The board has found the applicant meets requirements of the Harwich bylaws, Mass General Laws, Chapter 40A, Section 10, due to the shape, topography, and conditions of the land, and the failure of the board to make this grant will result in substantial hardship to the applicant. The board further finds the conditions is specific, property does not generally affect the entire district, and that there will be no substantial detriment to the public good by granting this variance, and that it granting will not nullify or substantially derogate from the intent and purpose of the bylaw. All work will be performed in accordance with the plans submitted to this application. During the life of the project, there'll be no demolition, exterior construction, of new landscaping between June 30 and Labor Day of any year. Issuance of this permit is subject to a special use permit site plan review by the planning board. A violation of the terms and conditions of this variance may be enforced as a violation of the Harwich zoning bylaws pursuant to General Law 40A, Section 7, and the Mass zoning bylaws as they may be amended from time to time.
Just an addendum on this thing is that the applicant's been granted a variance from 325 Attachment 2, Table 2, area regulations to construct a multifamily dwelling pursuant to the Howard zoning bylaws, 325, and MGL Chapter 48, Section 10. Can I have a second on this motion?
I'll second the motion.
Okay. And that's included the revision that I made. All those in favor of granting this motion?
Aye.
Motion is approved.
Thank you much.
Now, gentlemen, I know our general witching, anytime is 9:30, however, we started about 10 minutes late.
We'll be brief.
And we only have, we have two cases. One's gonna continuance, which is real quick. We have one final case, and I do recommend that we give the applicant the opportunity to hear the case tonight. Is there any disagreement on that?
Who's the applicant?
Here with Mr. Welch.
Okay. So, this would be, we're gonna hear the case for zero snow in road, but at the same time, I would like to have an agreement from the board regarding 24 Pilgrim Road. If we can suspend from reading in the case. And I do have a continuance request for 24 Pilgrim Road from Attorney Donovan, which I have a signed copy. And I would like to make a motion that we agree to this continuance. I'd like to have a second on that.
Second.
Continue it to May 28th.
Continue to May 28th. So this document allows up to 180 days.
They requested the 28th.
Because the 28th.
Yep.
Yes.
Correct. All right. So all those in favor of my signing the continuance?
Aye.
Okay.
That saved you another hour and a half.
Easily.
Tonight. So you'll only have to hear Attorney Singer's continuance and then this continuance. Next month.
Could you pass this down to Rachel, please? Okay, let's, hold on a second here. Now, here's the,
Oh, all right.
all right. So,
All right, case number 2025-19, James S. Welch, trustee to the Welch Green Family, Howard Court, City Attorney William D. Kroll. Attorney Mike Donovan is not here. Property is located at 0 Snow Inn Road, Assessors Map, parcel F2. Assessors Map 8, parcel F2. In the RL zoning district, the applicant seeks a special permit or the alternative, a variance from 325-54A7, alteration or extension of the structures 325, 3, Table 2, height bulk regulations, 325, attachment 2, table 2, area regulation to raise and replace pre-existing non-conforming boathouse pursuant to the Howard zoning bylaws, 325, 54, and 52, Mass General Law, Chapter 48, Section 6 and 10. The Howard Department, Health Department submitted comments indicating the permit must be applied for to connect the tight tank to the adjacent property prior to any building permit sign-off. Conservation Department submitted comments stating the commission approved the project. The Planning Department submitted comments indicating they had no concerns and no other comments were made by the town departments or abutters were received.
Attorney Kroll, you would make forward the case and introduce anyone who's helping you with this application?
Thank you very much. Thank you, first of all, for hearing us this evening and not saying we had to come back next month. And I will say that we met with the Historic Commission at 6 o'clock this evening and convinced them that the listing on the Historic Register was erroneous as far as the date of construction, being 1915, and they agreed that that was in error, and that the boathouse in question was constructed sometime after 1934. So they did not take jurisdiction, and we don't have to have a hearing in front of them. As far as the Board of Health is concerned, with the comments from Ms. Schoner, the health agent, we have been working with her since last fall, and because my client, Mr. Welch, I'm sorry I didn't introduce him, this is Jack Welch, the owner of the properties, but Mr. Welch and I have been working with Ms. Schoner since last fall to connect the bathroom that will exist on the second floor of the new structure to the tight tank that's on the other boathouse owned by Mr. Welch to the north. So there'll be a pipeline from this boathouse to that tight tank. If you don't know what a tight tank is, it doesn't let any effluent go into the environment at all, and it's pumped periodically. So that's the background. So Mr. Welch is requesting a variance under Section 7 because it's not a single-family residence. It's an other structure. He wants to demolish and replace the pre-existing non-conforming residential accessory building on the same footprint as per the plans that were submitted with the petition. So I'm going to try to be brief. Everybody wants to get home, and it's been a long day for everyone. The existing building is a two-story boathouse in Witchmere Harbor. The proposed building will also be a two-story building. It will be on the exact same footprint. There'll be no change to the footprint at all. There'll be no increase in any nonconformities. I don't think I need to go through the setbacks because we're not changing on any of them. And this is a unique, very unique lot. It has no frontage on a road. It's shoehorned, the boathouse is shoehorned into this lot as closely as you can. Some of the setbacks are 0. You don't have a front yard setback technically because you have no frontage on a road, so you don't have to be 25 feet.
Google does not recognize 0 Snow Inn Road.
So, in any event, I'm very familiar with this property. My family had a construction company in the mid-'60s. When I was in high school and college, we worked on this lot and the boathouse up the street, and built the pier that juts out on the Mr. Welch's other boathouse. So I'm very familiar with the property. The boathouse has been there for a long time. It's in tough shape now. It has potential structural integrity issues. He's experienced seasonal flooding. There's a foot or two when it's a storm tide, which raises more rot and mold issues. Has caused extensive water damage. So now this new boathouse, new structure would raise that first floor elevation to get rid of those flooding issues. So as far as a variance is concerned, if the variance is not granted, very simply, the boathouse will continue to deteriorate. I don't know what relief we have. Anybody that's got a garage, you don't have any relief in terms of a special permit. You have to ask for a variance, because you folks historically do not consider the garage as part of the single-family residence, or the other structure as part of the single-family residence, and therefore it has to have a variance. So the hardship to Mr. Welch is the continued deterioration of the boathouse. It needs repair. It needs to be restructured, rebuilt, and I would submit that it's been there a very long time. There would be no detriment to the neighborhood in terms of meeting all of the requirements of the variance. It's outlined in our petition. But this lot is unique in relation to other lots in the same zoning district, and it would cause Mr. Welch a substantial financial hardship, and relief could be granted without substantial detriment to the public good. It's going to remain a boathouse. The second floor, if you looked at the plans, show a writer's studio, right? Mr. Welch's daughter is a writer. So this is going to be a very good use for the family and for her to have seasonal use of the boathouse. Despite the lack of heat or air conditioning, it would be a great place for a writer to have a studio. So we would ask for those reasons that the board grant the variance this evening to allow him to demolish and replace and rebuild that boathouse. Thank you.
Absolute agreement, the fact that it's time for the house to be replaced. Time frame?
It would begin in the fall. Nothing in the summer. He knows the rules and lives across the street on Snow Inn Road.
So I'm not even going to ask a question about maintaining construction vehicles on the site.
I was looking forward to that question. We're going to use skyhooks and barge them in. I thought of that too, but no.
Where does one park?
Where the landscapers park on Snow Inn Road. They pull their truck and their trailer, the pickup truck and the trailer over to the side of the road, and everybody has to drive around them. There's no other alternative.
No, I realize that. I'm always amazed at some of these places, how they get built in the first place. That's
And
fine.
these were all separate land court lots. The two boathouses and the vacant lot in between, they're all separate land court lots, separate land court plans.
So F2, N4, and F3 are all
Separate.
That was one of my questions. They're all distinct lots. They're all owned by Ms. Welch?
I'm sorry?
Yes, just there.
Yes. And they go with part and parcel with the house across the street, with their house across the street. Did have
they be able to park the construction vehicles at the house across the street?
Some of them, for sure. Yeah.
That would be a possibility. I wanted to show you this lane court plan from 1970. If I may. This is the lot across the street. These are the three separate lots. Gives you some perspective. And this is the boathouse in question right here.
Okay, good, thank you.
That one right there.
Thanks.
So you hope to be inspired like Fitzgerald to see the lights across the harbor?
Across the harbor.
Riding river?
Yeah, great Gatsby, definitely.
Okay, Tim?
I have no questions.
No question.
No?
The only question I have, Mr. Welch, I'd like to know if, since his daughter is an author, does she have any current books?
She's a TV writer, and she lives in California, and part of my being more than you really want to know is to try to figure out how do I get her in the Cape more often. And if I thought I created something that she felt like she could write at, she would come visit me more often.
Very good.
But she lives in Los Angeles.
Good answer.
Right.
Yeah.
Maybe
Right. So
if
if
you
you don't
move in
grant
the-
it, it's a hardship to Mr. Welch.
Maybe if you moved into a boathouse and gave her 42 snow.
No, she yeah.
I have no question, no further.
Any, we all set, John? Yeah. Any questions? Okay. All right,
And there is another boathouse that just got renovated, a little, further north.
Further north, 49.
Right, and they did a great job.
so, just, I mean, I know we want to speed through this thing, so obviously, the other boathouse is on lot F3. The lot N4, there's nothing on it, correct?
Correct.
Okay. And then we have lot F2. Okay. And I'm assuming there's no one in the public that's going to speak to this, since we're left here. And
Fair assumption.
hearing no one, no additional questions for the applicant, gentlemen and ladies? Okay. All right.
And it is refreshing to see a young lady on the board.
Yes.
And that doesn't have an Irish last name necessarily.
Henry VIII.
Jim Cole, you have a copy of the findings of facts and so forth?
I do. I
Okay.
have one suggestion on that. I spoke to Rachel about it. This one also says special permit instead of variance, so she was gonna modify that.
You gonna make that question, Rachel?
Yep.
But I'm okay with the documents that you cite in there and the findings.
Okay. Anybody have any additions to any of those findings and so forth? All right. So, that being the case, I'd like to make a motion that we accept the documents, findings of facts. And regarding conditions, obviously the date requirement, June 30th of Labor Day, all right? And the standard violation in terms of zoning bylaws. Okay, anything, all set with all that, guys? Gentlemen, okay? All right, so, I'd like to make a motion that we do approve the documents, findings of facts, and condition approvals as stipulated.
As amended, I make
As
that
amended
motion.
with the variance here, and second by Ken. All those in favor?
Aye.
Aye.
All right. I'd like to make a motion, I'd like to have someone make a motion to close the public hearing.
So moved.
Second by Tim. All those in favor?
Aye.
And voting. Al Donahue, Tim Bailey, John August, Ken Dixon, and Marilyn Rotz. So, I'm not going to vote. And can I have a motion from the clerk, please?
Case number 2025-19, James S. Welch, trustee for the Welch Green Family. The property owns property is located at 0 Snow Inn Road. The board has found that the applicant meets the requirements of the Harwich bylaws, Mass General Law, Chapter 40A, Section 10, due to the shape and topography and condition of the land, and failure of the board to make this grant will result in substantial hardship to the applicant. The board further finds that the conditions are specific to the property, does not generally affect the entire district, and that it will not substantially be detriment to the public good, granting this variance, and that it granting will not nullify or substantially derogate from the intent and purpose of the bylaw. All work shall be performed in accordance with the plan submitted with this application. During the life of the project, there'll be no demolition, exterior construction, nor landscaping between June 30 and Labor Day of any year. A violation of the terms and conditions of this variance may be enforced as a violation of the Harwich zoning bylaw pursuant to General Law, Chapter 48, Section 7, and the Harwich zoning bylaw as these may be amended from time to time.
I gotta read in this paragraph.
The applicant has been granted a variance from 325-54A and 7 alterations or extensions of other structures, 325, Attachment 3, Table 3, height and bulk regulation, Attachment 2, Table 2, area regulation, to raise and replace a pre-existing non-conforming boathouse pursuant to the Howard zoning bylaw 325, 54, and 52 of Mass General Law 48, Section 10.
Thank you. Excellent. Okay, any further discussion?
Was there a second to that motion?
Not yet.
Thank you.
I have a second to the motion, as
Second.
requested by the attorney.
Thank you.
Hold on.
And any revisions? All those in favor of the motion?
Aye.
Aye.
Okay, approved, 5-0.
Thank
Okay.
you very much.
Pleasure.
In relation to another Jack Welch that lived in Westport, Connecticut?
No, but I've been asked that question quite a few
I can
times in my
imagine.
life.
Drive by there all the time. Renovated his office in a past life.
Yeah. Asked that question quite a lot. Thank you.
Did you
Okay.
Thanks again. Good night.
Good night, guys.
Good night.
Welch's office.
Okay. Actually, on the minutes, because I was here and, anybody, everyone read the minutes? Those who are here, any questions regarding changes? I think Ken brought to my attention that perhaps missing the minutes was, there was a discussion regarding the ADU changes that I just brought up with the Board of.
Is it not in there?
Oh, it says it was just discussed, but didn't say what was discussed. I was just having missed. the
Okay,
meeting, that's
all right.
Yeah, but that was definitely a topic addressed.
That's okay,
Yeah.
okay, good, okay. All right, anybody have any changes to the minutes? I'd like to make a motion. I'd like to make a motion that we accept the minutes.
Second?
All those in favor?
Aye.
All right, okay.
Abstain, was not present.
All right, so we've got, actually, four zip and 2 abstain.
Who's the other that abstained? besides Dixon.
Well, did you vote, Marilyn?
I didn't, because I wasn't
Because,
at the
yeah,
meeting, I
because of the
can't,
meeting, so
I can't vote.
Marilyn abstained and Ken abstained. All right, well, I think your first meeting, Marilyn, you had a long haul. A lot of interesting discussions tonight. Appreciate everyone's perseverance getting through everything. I know that I obviously increased the amount of time as well with my,
No, you did a fine job.
my discussion on that.
I have one old/new business thing.
Yes.
In regards to the 40B, which is obviously not discussed today, it's obvious we're gonna get a lot of correspondence. Is it possible, Rachel, to have a central file that we could all review, or even
Well,
a shared Google file, instead of all of us trying to
every
keep track
day I
of?
upload if I get comments, I upload them every day to the website.
It's on the website. But you're also sending us copies of what,
I know you're sending copies, but I mean, there's gonna be,
I don't have
A
to
lot
send you an email every day if you don't
Yeah.
want me to send you.
I'm just thinking a central binder that if we wanted to flip through it.
oh, I see what you're saying. You want to have one binder made, so that's
Yeah, one
on your
ring to-
desk.
Yeah, one binder, because just in case you missed anything, or just to know there's one copy that has everything in it.
Yeah, I have a file in my office with all the hard copies of the correspondence I'm
Rather than
receiving.
wasting reams of paper in all our.
So as they're coming in, you're copying them and putting them in our file jackets, is that correct? Or what? What's the plan here?
Well, does the board want me to make hard copies of every correspondence I get and give it to you at each meeting of every?
I was proposing this binder in lieu of that. That we could, at our leisure, peruse the binder rather than all of us trying to keep track of whether we had the right copies of everything.
Is there a way to, for us to access electronically?
Everything's uploaded to the website.
And it's
Okay.
uploaded at date range, correct? Like it's put in chronologically?
I date the letters the day I receive them.
No, but when they're in the website, it's
They
like,
get uploaded alphabetically, and the files are labeled according to
okay.
the first initial and last name of the person submitted in the letter, and then the date that I got the letter.
So it's not being uploaded chronologically?
It's
Right.
being uploaded chronologically, but it's not being organized.
Well, no. But when it's on the site, it's not in chronological order.
Right, but it's
Yeah.
dated. The letter is dated the day I receive it.
Yeah, but what I was referring to, also you can flip through and see the next.
Yeah, but
last
I mean,
four.
I'm just envisioning if we get 100 letters.
Yeah.
To try to go to the website and find the most recent letter is scrolling through all of us doing that.
Well, they're gonna be dated.
Yeah.
I know, but if it was loaded, if it somehow could be maintained chronologically as opposed to alphabetically, you just go to today's date and see what got uploaded yesterday. That's,
All the letters are gonna have the dates on them that I received them.
but you have to go through them all in order to find the dates. If you just open it up and just go
I
to.
don't have a way
Yeah,
to
I realize
organize
that.
it on the
Yeah,
website
that's what,
that way.
yeah, that would be great, because then we can every day load up, okay, what came in yesterday?
Having never looked at this before, my concern is, are the letters for the 40B mixed in with letters from other cases?
No.
Or are they in files? They're in folders for each project?
Yes.
Okay, great.
Yes.
That's good. Thank you.
So I have a file in my office that has all the hard copies of all the letters, and I'm uploading them to the website daily if I get them, if I get any in that day.
Again, it was just a suggestion. I don't know if anybody else on the board, but for me, especially as we get closer to voting, be able to go back and review the comments, both for and against, in one big pile instead of dribs and drabs over the whole summer. But I'm okay if the rest of the board doesn't do the same way I do.
I do think I have to share them with you when I'm receiving them.
Yeah, I just didn't have you share it, and if you do that, I appreciate it.
I mean, I hate to send a million emails with a million.
Well, that's what I
comments,
mean. I
but-
realized 2 days ago that I missed
Yeah.
one email that
I
had
know.
letters from,
Yeah.
received prior to the last meeting, but I hadn't read it, and then I read it, and I'm like, all right, well, this is gonna be a pain to try to.
Your file, is that chronological?
John.
No, I don't think it's chronological at this point, but I can reorganize it.
If, my recommendation would be on your
This is
file,
long hair.
do it chronologically. So then if we pop in the office, we can look at the last date we looked at.
Yeah, I can do that.
Okay, that'd be great.
But does the board, is the board okay with me still sending them via email?
Yeah.
You know, I was looking at this as like a fail-safe, to
Okay.
just make sure
Yeah.
you didn't
Yep.
miss something.
Ron, at some point here, let me know when you've completed the mowing.
I will do that
Marilyn
very
would like to
soon.
make a motion to adjourn.
I have a new business.
No, but before we, well, we're still on the 40B, and I don't want to get a big discussion on it tonight, and we can probably also communicate. But for the next meeting, prior to it, there will be a scheduled date where I'm meeting again with Rachel, Christine, the attorney, our town attorney, and Judy Barrett, the consultant, to review, the next meeting, okay? My recommendation is that regarding, particularly all the waivers that are being requested, that we do address the waivers when we get into each meeting by topic, that we review those waivers by topic. Okay? That way we can just start, and then, look at it that way, and I'm saying, when I say review it, I'm not saying vote on it necessarily, but have a discussion at each thing here regarding the waivers for that thing here, and just get kind of consensus as we discuss it and get input from the community, okay? All right. But after I have discussions and so forth, and prior to that, I may have individual conversations, whatever, you guys, regarding your thoughts, for the next meeting. But I do it individually and not on a quorum basis.
Are we confirmed on the site visits? Are we gonna get logistics for those?
I'm waiting to hear back from the applicant about the logistics, but the dates are confirmed. But,
We're also trying to establish dates, if not, they can't make those two dates, which are the 10th and 17th.
well, they agreed to them at the last meeting, so.
Right, but any department heads, conservation, et cetera, that want to do a site visit as well, Christine, Flynn, so forth. Anyways, town employees in key departments have been invited to attend a site visit, and Christine is working with the applicant if a separate site visit date may need to be established. That was my last conversation on that, just so you know. So we're gonna get, as the department heads provide us further input, whether it's just through a written statement or perhaps appearing at a meeting, we'll see. But I think a site visit this time would be very appropriate for them as well. So, new business.
I'm just gonna let you know that I am not going to be here on May 28th from a quorum standpoint, so I know now I'm gonna be out of the country.
Okay,
And I don't know if Chris is gonna be here either, just FYI,
on the 28th.
on the 28th, which is our regular meeting, not a 40B.
Okay. Gotta see if, make sure Dave knows he's gotta be there. 28th.
Is it?
And is everyone all set for the 18th of June?
Absolutely.
Yes. Okay. And Al, did you have a chance to reply to Rachel regarding all the Wednesday dates going into October?
Yes.
I didn't receive anything. I just assume you're gonna be there.
Okay, all right, so you're all set in all those Wednesday dates? Okay. And I think, who else was that time that we didn't, did everyone reply to?
Yeah, we're all set then.
So right now into whatever date in October, there's only a possibility of John missing.
Yeah, I have an arbitration that I'm gonna have to attend in New York that's tentatively
Right,
late September, early October, but it could easily get delayed.
okay, all right, so we're in pretty good shape. Excellent. Well, I think, like to, if you guys want to hang around for a while, let me know, but I'd like to, I would entertain a motion to adjourn.
Only if they're going to be cocktails.
So-
Rachel, I was making an observation. I think Marilyn's last name has been misspelled through most of this.
We,
How do you spell your last name?
I think this is right.
Okay,
Yes, this is right, and it's pronounced Rats.
okay. So,
It was spelled R-O-A-T-Z, at least in the documents I had.
yes, it was, and so that's how I had it, so I apologize.
yeah, I don't know.
It's a
I didn't
terrible
write those
name.
documents, so
So anyways,
Someone did.
that wasn't me.
make note of when I, because all
Blame
the,
him.
Yeah.
yeah, so I apologize.
I didn't notice.
Motion adjourned?
So moved.
Second.
All right, all in favor?
Aye.
Aye.